All right, ladies and gentlemen, we're going to call to order our first hearing of the evening. This is a continued hearing, and it's on the application of Giancarlo Francesconi and Carol Commercian. The applicants, they live at 7 Brookside Park in Milton, Massachusetts, and they appeared before the board on December 10, 2013, seeking variances to put an addition on the rear portion of their residence at 7 Brookside Park, Milton. They sought a variance from the terms of Section 6A of the bylaw to vary the maximum height from 2.5 stories to 3.5 stories, or 31.4 feet above mean grade. And then there was a question of whether they also needed a variance under Section 6E4 regarding the total gross floor area. The applicant took the position at the last hearing that such a variance was not required, but after further inquiry with Mr. Prondak, our building inspector, I believe the applicant now concedes that he does need that type of variance, but I'll leave that to Mr. Corcoran. My name is John Leonard. I'll be acting as chairman of this continued hearing. With me tonight, to my immediate left, is board member Virginia Donahue King, and to my immediate right is board member Theodore Daba. The rules of the board are going to be the same at this hearing as they were from the original hearing. We'll first hear from the applicant, then we'll hear from any person present who wishes to ask questions of the applicant. We'll listen to people who wish to speak in support or in opposition to the particular applications for variances. We're tape recording the proceedings this evening, so that would ask that before anyone speaks, speak up nice and clear and loud, tell us your name and address. We have a big room here. It's very difficult to pick up things on the tape recording, so we want to be sure that we have a full and accurate record of the proceeding in the event that we need to revert to the tape in order to prepare a written decision. Since the last hearing, the board has received several additional materials. We received a memorandum dated December 30, 2013 from Kevin M. Blow at 31 Brook Hill Road, who's the direct abutter to the subject property. It's a fairly lengthy memo, and I understand Mr. Blow is going to be here this evening. He's got a series of photographs that he's going to share with the board, but in essence, he says that the photographs indicate the adverse effect that the proposed addition would have on his personal residence, and so he objects to the variance. Mr. Blau, I believe, also submitted some written materials at the last hearing, and I believe spoke in opposition to this variance application. We did receive a very short note from Jill Ann O'Donnell of 7 Brookside Park, and I'll read this because it's sufficiently short. She says her name is Jill O'Donnell. She resides at 20 Brookside Park, and she'd like to have her name removed from the list of supporters that was presented to the board at the first hearing in December for this proposed addition. She says she signed the support petition before she had a full understanding of the planned addition and without knowledge of the, at least in her opinion, the alleged negative impact that it would have on the neighborhood. So Ms. O'Donnell wants her name removed from the list of supporters for this particular application. We did receive a memorandum from Attorney Gene Voveris and Peter Prophet. They reside at 7 Brookside Park. They're direct abutters to the subject property. This is a 3-page memo, and Mary, why don't you close the door and tell them to keep quiet, please. I'm not going to read this memo. It's here if anyone wants to read it. It's pretty much similar to the memorandum that Attorney Voveris submitted at the original hearing, though he or she notes that the application does require a gross floor area variance, and she thinks that the variance is excessive, and she requests that the application be denied both as to height and as to gross floor area on the basis that it would have adverse effects on her personal residence. We also received a email from Richard W. Proctor. Mr. Proctor writes to the board on January 6, 2014. I don't see Mr. Proctor's address in here, but it may very well be. I'll summarize this because I think this is the first communication we've had from Mr. Proctor. He says his family's been residents of this area of Milton since 1938, and they've seen this portion of Milton grow. They know many of the neighbors. A small portion of Mr. Proctor's land does abut Mr. Francisconi's property. He says that the walls of the neighborhood are closing in. He's worked at Milton Hospital for over 30 years, and now he's a prospective home seller in this particular area of Milton. He's concerned with property values and those property values of his longtime friends and neighbors. He asserts that variances were put into place for a reason, and no one is going to be happy with the outcome of this proceeding. I think that's probably given from what I've heard from all of the various people. He says that he knows Mr. Francisconi. In fact, his mother knew Mr. Francisconi. They've been good friends and neighbors for years. He's been kind to his mother. He's cleared snow from her walk. He's a truly wonderful neighbor, and he hates to see the conflict that is now going on between our neighbors. I won't go further than that. He says that the problem is that we have to be concerned about future neighbors, and not only the present neighbors. Milton has beautiful neighborhoods. No one wants to live so close to others' homes, and that the variance petitions of the bylaw were put into place to protect those privacy concerns. He knows that Mr. Giancarlo's home is close enough for him to work to his place of business. He says it's a luxury that not many have these days. He says there are several homes in our neighborhood that are currently up for sale or soon will be, homes that may afford more space that Mr. Giancarlo and his family are looking for. He would like to keep him as a neighbor and keep him close to his business. He realizes that it would be a huge sacrifice and difficult for Mr. Francisconi to change his residence, but according to Mr. Proctor, quote, "We can't always get what we want," close quote. Sacrifice and hard decisions will have to be made. He's not for the allowance of this particular variance for only one person's property when it affects so many others, as well as future homeowners in a negative way, and he would not ask or expect it of his neighbors or the town of Milton. So we thank Mr. Proctor for his kind note. We have some communications that Mr. Edward Corcoran, the attorney for the applicants, sent to both of the abutters on or about June 7th. Mr. Prondak completed his calculations, and he found that the applicant, in his opinion, does need a gross floor area variance that is significantly larger than the applicants originally believed they needed. Apparently the principal reason for that, according to Mr. Prondak, is that he's including the basement area as part of the calculation when he says he didn't really appreciate that until he reread the bylaw. So that he concludes that the proposed addition would have a gross floor area of 4,889 square feet, and so that's about 89.5% of gross floor area rather than the 60% that had been previously anticipated. When Mr. Corcoran learned of Mr. Prondak's calculations, he sent letters to the abutters, Attorney Voveris and Mr. Blau, dated January 3rd, 2014, advising them of Mr. Prondak's conclusions so that they would be aware of it and be prepared for this particular hearing. So with all of that, we certainly thank all of the neighbors for sending in materials and stating their views, both publicly at the last hearing as well as in the interim period of time. So rather long preamble. Mr. Corcoran, welcome back to the Board of Appeals, and why don't we hear from you?
Thank you, Mr. Chair. With the board's permission, I'm going to stand because I think I can be heard.
And I should say this, if there's anybody who can't hear Mr. Corcoran, for whatever reason, he turns away or lowers his voice, or if you can't hear anything that any of the board members are saying, just give us a wave and we'll make sure that you can hear everything that's said at the hearing. Mr. Corcoran, please.
Thank you, Mr. Chair. I've got, I think, three main areas to cover. I'll cover as quickly as I can. I know, I appreciate the fact that we're here for a second night. I did, after the question was raised at the last hearing, revisit with Mr. Prondak the question of the gross floor area. I think the question that was asked at the time went to what was the total based on a percentage comparison of so-called Plan A versus Plan B. I met with Mr. Prondak, our engineer met with Mr. Prondak, gave him the plans. He reviewed the plans directly on his own. And his conclusion was a total gross floor area of 4,889 square feet. I learned of that in a voicemail from Mr. Prondak that I received. Arrived in my mailbox at the end of the day on New Year's Eve. I picked it up on January 2nd.
Happy New Year greetings.
And I immediately, I know I called you, Mr. Chairman, that night, and the next day, sent a letter to the neighbors identifying the conclusion that Mr. Prondak had reached. He sent an email to you today, copied to me, that included his calculations, because I didn't know what was included in that total. And he identifies a number of I've got extra copies of Mr. Prondak's email to you. But when I went back, if you take the basement out, the calculation of gross floor area is 3,659 square feet. If you take out the two basement areas, which was approximately the same amount that we had suggested was the gross floor area, we said in the plan was 3,621 square feet. Either of which is less than 3,750 square feet, which is the maximum allowable gross floor area under the bylaw. So in our understanding at the time, without the basement, we understood that the gross floor area was less than the maximum threshold for variance. I didn't see that part of the bylaw. I think when Mr. Prondak issued his first determination, he didn't see that part of the bylaw. He then re-reviewed and came up with that determination. That basement calculation really drives, at the end of the day, it drives both requests for variance. Because the determination that the basement must be considered a floor, because the first floor elevation is higher than 4 feet above the existing grade, renders this house a 3.5-story house. And it means that its existing, the existing gross floor area without any addition is 3,800 square feet, which is more than, it's 3,856, it's 106 square feet more than the threshold that would be allowed otherwise. So that's the, we know now we need variance from two standards. I received a copy of Mr. Blow's memo yesterday by email late in the day from Mary Fitzgerald. And so that struck me to check some town records based on how did the town records recognize the gross floor area and the height of the buildings on either side. Because visually, the Blow house is significantly larger. I'm going to get 3
Thanks.
That and an extra to share. The blow house is significantly larger visually than the Francesconi Camerton house. So I got copies of the town. Fortunately, I thought I had extra copies. It looks like I have. Yeah, why don't we just pass this. So I got the town records with respect to the relative size and density, and I highlighted the critical areas on the second page of each. So the town recognized in its records that the Francesconi gross floor area would be 3,945 square feet, which is very close to what was calculated by Mr. Prondak. He's at 30.
Is it for, oh, you
At
mean
3856.
Without the, sure.
Where the town's records are 3945. If you look at the below Levine house, which is to the right, second page, they're at 5687. There's 800 square feet approximately greater in gross floor area than the house that the Francesconi Camerton family owns. The below photographs suggest that the impact of what we think is a reasonably scaled addition to the Francesconi house will have significant impact on their views as they look to the west. If I'm standing in the Francesconi house and I turn, I'm looking up at a structure that's significantly taller, larger than what would be than what would exist if the variance is granted. And I have some photographs that were taken from the Francesconi residence, which depict visually what I'm talking about. So we're asking for a variance to allow an addition to a house that is still going to come out to be 800 square feet less than what exists immediately next door on the right-hand side. That house is non-conforming. This house is non-conforming. Every lot in the neighborhood is non-conforming with respect to size. And if you looked at the plan, the old subdivision plans that I included with the original application, you can see that none of the lots are conforming. The third issue I would raise, only with respect to the Voveras Profit House, is that although the gross floor area is only 2,500 square feet, it is a much smaller house. I think it's the smallest house in this little neighborhood. Their basement is still considered part of the gross floor area. And if you look at the photograph in the town's record, the basement appears to be at least at, the first floor level seems to be at least at 4 feet above existing grade. So that, I think, is something of a consideration. I checked also with respect to variances in the area.
Can I stop you just,
Yeah.
let me ask a question that may be a silly question, but I can't find it quickly. With respect to the Francesconi house, and we agree that the whole area is non-conforming, and zoning speaking, it's a mess. When was the Francesconi house constructed?
1904.
Okay.
All of the houses in this lot.
How about the second house, the below Levine?
19, about the same time, early 1900s.
Okay,
The Viveras house was built in 1963.
right.
It's the only house, I think, that was built post-zoning.
Okay.
I
don't
did
think
an
it's-
analysis of the title, relative title, because the second issue here, I think, deals with, there was no variance granted, but in 1952, the Francesconi house and the Voveras house were part of the same lot. They're shown as two lots in the 1898 subdivision, but they were owned in common ownership. in the 40s and 50s. And in fact, were deeded, and I walked through the title, wasn't I did. In fact, were deeded by one William Joy and his wife, who apparently owned both lots at one time. In 1952, they acquired both lots under a single deed from the estate of Anthony Anderson. And both lots are described in the deed. After my summary, it's the first deed on the next page. Describes them as a certain parcel of land with buildings thereon, now numbered 7 Brookside Park, being a part of, shown as Lot 3 and a part of Lot 4 on the 1898 division. Described further as bounded southerly by Brookside Park 100 feet, containing 10,695 square feet. In early 1953, the next page, there's a subdivision plan that was created presumably by the Joys that redivided those lots into 2 lots, Parcel A and Parcel B. Parcel A being the Francesconi property, 5461 square feet. Parcel B being the Voveris property, 5234 square feet. 50 feet of frontage for each lot. So we took 2 lots that had merged legally and then redivided. Now, nobody asked any questions, I believe, because the Joys conveyed at the same time that the plan was created to predecessors in title of Francesconi's. That's the Haggertys. The first deed, the next one is a deed to Haggerty. And the Haggertys lived for 8 years in the 8 years in the property and sold to someone named Balico, who lived there from 1961 until he sold the property to the Camersons in 1997. The Joys then, at the same time that they conveyed to the Haggertys, within 4 months, conveyed to someone named Alexander Manning, who held for 8 years, sold to someone named Crosby, who held for 2 years, sold to someone named Desmond, who built a house, and sold to the Voveris family. The Voveris family appears to have owned that lot since 1963. I think no variance was requested because 10 years after the division happened, these lots are now in separate ownership. No one thought to ask the question. That's a long way around to suggesting this. This is a small subdivision that was created in the end of the 19th century. Houses were built, it was small. This is a house that has a small kitchen, 1.5 baths. They were built to an old standard. They were built to standards that wouldn't be allowed today. It is reasonable to think that the town ought to be granting variances in matters like this, where you're trying to add a reasonable amount of space to accommodate today's needs. These are the 2 smallest houses in the neighborhood. It is reasonable to think that they ought to grant a variance here. The hardship is created by the fact that you have a 4-foot slope from the front corner of the house to the rear corner of the house. If you look at the plot plan that was created, just from the front right-hand corner of the house as you face it to the rear left, there's a slope of about 4 feet. That's a significant drop in elevation that is unique to this property. That creates the issue of the basement as a third floor. And that's what drives the need for variance. If that basement is not calculated as a story in this case, we don't need a height variance, and we don't need a gross floor area variance. We need those in this case because of that calculation. That is driven by the change in elevation. The law in Massachusetts, as I know you know,
indicates that where you're looking for dimensional variances, we're not changing use, we're not adding nonconformities, we're simply adding, looking for dimensional modifications to existing nonconformities, that the standard may be less strict than otherwise. I think in this case, we're asking for a reasonableness determination that what the Camerson Francesconi family is looking for is reasonable, and it ought to be granted. This is a difficult case, I know, for all parties. It's a tight neighborhood. But this is a reasonable request for variance.
Okay, thank you, Mr. Corcoran. Let me see if my colleagues, Mr. David, do you have any questions of Mr. Corcoran?
I don't think so right now. Thank
Okay,
you.
Mrs. King, do you have any questions? Okay, let's thank you, Mr. Corcoran, for your presentation. Let's see if there's anybody who wants to be heard at this hearing and who hasn't spoken at the previous hearing in support of this application for variance. So the record will indicate there's no such person present. Is there anyone present this evening who either has questions of Mr. Corcoran or wishes to speak in opposition to this application for variance, while understanding that we have 2 more hearings after this, one of which is going to be a lengthy hearing? Attorney Voveris,
Thank you.
welcome back to the Board of Appeals.
Very much. I heard you received.
No,
my
why don't you-
submission.
Yeah, sit right up there if you would, and we're going to take one of the microphones in place. Or you can take the microphone down and sit here, wherever you want, as long as you have the microphone.
As Attorney Corcoran stated, we did receive a letter. We didn't get it till late yesterday, which is why I didn't submit my comments until today, confirming that indeed what we suspected, that the plans in question do require a gross square footage variance. You know, frankly, I was a little confused by Attorney Corcoran's testimony. It seemed like, or his commentary, it seemed like he tried to put us in the position where 2 of the abutters in question were asking for a variance here. It really, in my mind, it's completely irrelevant that the Blow house is larger than the Francesconi's house. They were aware of that when they moved into the neighborhood. They are not looking for a variance today. It's completely irrelevant whether or not there was a variance granted on our lot. You know, we're here today because, you know, I spoke to the height variance the last time. We're clearly still objecting to that. With respect to the gross square area, it's not minimal, as the applicants argue. You're looking at something that is 90% of the total area of the lot. There is no way the board can consider that minimal. I think it's really important for the board to note that, and I'm going to pass out this picture. I believe this is actually the applicant's picture, but it sort of struck me today when I was looking at it. This is an aerial photograph of the lot. The highlighted homes in question around the applicant's property, those are the only 3 direct abutters to this property. Each of those 3 people is opposing the variance in question. It's going to have a significant impact on each of our properties. I hope the board fought the weather and had an opportunity to go out and do a site visit of the property. Because I think, as it's pictured in there with you, when you're looking at the existing square footage of the lot, when you're looking at the size of the barn, when you're looking at the incredibly large size of the addition that they want to put on, this is an incredibly large addition. This is bigger than a lot of people's condominiums. I mean, it's not small by any stretch of the imagination, and it's going to significantly impact me and my husband and the other abutters in terms of our light, our open space views. It's going to change the character of living at our properties, and it could decrease our property values significantly. You know, for that reason, we're opposed. And again, as I clearly, I think, explained in my memo, you know, obviously, there's no right under the law, you understand this, for a variance. The applicants haven't proven their case with respect to the elements of the variance. We spoke last time about the idea that they haven't shown that the condition of their property is unique. Today, they seem to be suggesting it is somehow unique, although earlier in Mr. Corcoran's statement, he mentions that my property has the same condition. That would not be unique. Other properties in the neighborhood, I question whether indeed, looking at that property, it's 4 feet slope from front to back. It appears to be 4 feet from the front of the property to the rear of the property, as opposed to dealing with the house. But, the condition, the hardship that we're hearing about is their need to have a larger house. And that's perfectly understandable. Lots of people would love to have a larger house. But that doesn't qualify as a hardship under any case law for a zoning variance. You're not depriving them of a reasonable use of their property if you deny the variance. They have a perfectly acceptable, marketable house on that property if we apply the zoning code the way we should. So for those reasons, we're objecting to the variance
Great.
request.
Thank you for coming, and thank you for your memorandum of law. We appreciate it. Is there anybody else who'd like to be briefly heard? Yes, sir.
Hi, Kevin Blow, 31 Brook Hill Road.
Welcome back to the Board of Appeals.
Thank you very much. Just two quick things, just to reiterate that, our house was built in 1904. When the Francesconis moved in, they knew what they were getting, and so this is different because we moved in and we thought we were getting, a view, and now it's changing. So that's why we're fighting it. So there is a difference between those two things. And then just, I wasn't going to bring this up, I thought it was kind of quibbling, but since the attorney made such a big deal about the basement, I have to say, it's not unfinished, They have carpet down there, they have a television down there, it's living space. So, I wouldn't have quibbled about that, but since the attorney made a big deal about it, it really needs to be included in the, the calculations, so that's all.
Great, thank you very much. Is there anybody else who'd like to be heard on this application? Okay, the record indicates there's no such person present, so, Mr. Corcoran, unless you have something further to add,
No, I don't.
okay.
Thank you.
My colleagues have any questions of anybody who has spoken?
No.
Mrs. King? Okay, so we have no questions. The evidence is concluded. We're required under the open meeting law to discuss this application in open session and vote on it, and we intend to do that here and now. So let me ask Mrs. King, do you want to be heard?
Certainly. This is a difficult case in that it would be a very nice addition for the applicants, but not a very good addition for the neighborhood. The standards that need to be met, I don't see have been met in this case. I know it's a difficult lot. I know that there's a slope down to the brook. The other properties on that side of the road have that as well. It's not something that is unique in the neighborhood. The entire neighborhood is faced with that issue. And if all of the people of the neighborhood were to get variances based on the same reasoning, this would be a neighborhood that nobody would want to live in. And I think that we have a duty to the people that do live in the neighborhood to preserve what it is that they feel that they have pretty much a right to when they buy into a neighborhood that is protected by zoning. So my thought is, unless I'm convinced otherwise, that I would not be voting for this application.
Okay, Mr. Deba.
I agree, it's a very difficult case. I think it was well presented, and I am very sympathetic with the applicants. I agree, though, with everything Mrs. King has said, and we hear at times of this, the provision that, as Mr. Corcoran pointed out, basically creates the the need for a variance with the measurement, counting it as an additional story, but that's part of the zoning ordinance, and we can't pick and choose which provisions of the zoning ordinance to pay attention to and which ones not to pay attention to. And unfortunately, I agree that unfortunately for the applicants, I agree that the requirements for a variance haven't been met, so I would not be inclined, unless I'm convinced otherwise, as well, to vote for it.
Well, let me start out, and I apologize for not doing it at the beginning of the deliberations, but to thank Mr. Corcoran for what I thought was a wonderful presentation. I don't know what else he could have done. I certainly want to thank Ms. Voveris, Attorney Voveris, for submitting some wonderful memorandum of law. The neighbors here, in my view, are well-motivated. There's no ill will here. They all speak very highly of the applicants, and I think you probably won't take a lot of solace at that at the present time, but I think it's important. It's one of these cases where you have good people on both sides of the equation. And the board, from my perspective here, has to make its decision based upon the facts and the law, and not whether we like the applicants, whether we like Mr. Corcoran or we like the people who are objecting. And I think one of the difficulties you have here is that this is a very old neighborhood. All of the lots are non-conforming. They're very, very small lots. And we see many times in Milton, we're dealing with 4,000, 5,000, 6,000 square foot lots and growing families. You really can't build a very big residence on that type of house. And so people come in and they ask for variances, they ask for additions. A lot of times they get the assent of their neighbors, and there's agreements that the variance can go through and there's no opposition. And we tend to be forgiving in those types of cases where there's no opposition. Or if there is opposition, if it's for an invidious reason. But that's not this case. And in those cases, we have to make a determination, and we do in every case, even if there's no opposition, that the variance won't substantially derogate from the intent of the bylaw or otherwise adversely affect the neighborhood. But where you have a variance that is opposed in good faith, we have to apply the standards of the bylaw, to be frank about it. And I spent some time this afternoon thinking about this case and looking at some of the decided cases that deal with issues just like this one, to be frank about it. And I was shocked that there were so many cases that deal with pre-existing neighborhoods, small lots, and people trying to increase the size of the residence under the variance process. And I'm not going to read cases to you, but there were a couple that I thought were very instructive. The Coleman case, which is at 281 Mass. 112, and the case talks about the standards for variance being sparingly granted and only in exceptional circumstances and that type of thing. But the case emphasizes that those variances, if they're being applied for, due regard to the main purpose of the zoning ordinance is to preserve the property rights of others. And that's the purpose of the bylaw, is to preserve other people's property rights. In the Gallo case, it's Dwyer versus Gallo, 73 Mass Appeals Court, 292. Here, the plaintiffs who were seeking the variance, they lived in a neighborhood where the construction was already more dense than the bylaw allowed. And the court, the appeals court, says that the abutters possessed a legal interest in preventing further construction in a district where the existing development is already more dense than the zoning then in force allowed. It's interesting, I have an appearance this Friday before Judge Piper in the land court. I think he's a brilliant jurist, and he wrote an opinion which is Patinella versus the Salisbury Zoning Board of Appeals. and it's at 19 Land Court Reporter 340. And where he was dealing with the situation was just like this. Admittedly, it was kind of waterfront property, but it was very tight development, 4,000 square foot lots. And he indicates that the appellate courts recognize neighbors' rights to protect their property and to contest zoning applications for variances where their excess density pushed themselves in a materially intrusive adverse way in the neighbor's direction. And he cites Shepherd versus the Zoning Board of Appeals of Boston. So that it seems to me, and interestingly, the Shepherd case that he cites, that was a case where the neighbors were contending that there was going to be decreased light and privacy because the house that was going to be constructed was too close to their property and would have adversely affected their enjoyment of the property. And to me, that's just the case that Ms. Voveris was trying to make to the Board of Appeals. We did, at least I took a view of this property, and I took it before the snows came. And I took it at 3 o'clock in the afternoon. It was getting dark. I was glad nobody called the police as I'm sneaking about the backyard. Nobody chased me away thinking I was a burglar. But when you stand in the backyard of the Voveris lot and you look at this particular property and you look at the variance that they're seeking, there's absolutely no doubt that you'd think that the house, the Francisconi residence in the addition is going to fall on top of the Voveris lot. It's going to be so imposing. It's certainly going to block any views and light. And I think taking a view of the property here, as we have in some other cases lately, is really important. And you see more when you take a view and you go up to the greenhouse at the corner and you look down and you see that these, in my view, their claims and objections of the neighbors, all three neighbors, and I think their claims have merit. And the terrible part of all of this is it's fun to sit on the Board of Appeals. It's just tough to make decisions where you have good people on all sides of the issue. And I know in some neighborhoods, if you had no opposition to the variance, you'd probably get your variance. And in those cases, and perhaps in your case, we see instances where the house just isn't big enough to live conveniently. And you either have to move to another neighborhood, buy a bigger house in this neighborhood, and probably spend a lot more money. And some of the people that appear before us, I hope you're very successful in your business and in your radio show and all of that. Some of them don't have the money to spend $800,000 or $900,000 to buy a bigger house in Milton, and they have to move elsewhere. And it's really a terrible issue, but we have to make this decision based upon the law and the facts, and I think the law and the facts are both against the applicant here. And I tend to think, and we can't render decisions because we think you're nice people and we know you need more space, because you do. You're nice people and you need more space. But on the facts of this application, the law is against you. In my view, I won't say we're doing you a favor by denying the application for variance, and I really mean that. But if we allowed this variance application, you'd spend a fortune litigating this case in the Superior Court of the Land Court. And in my estimation, it would take a Superior Court judge or a Land Court judge about 15 minutes to reverse our decision if we gave you a variance here. Because it's not really warranted on the facts and the law. This neighborhood is totally non-conforming. It's non-conforming all over the place. And the Gallo case that I mentioned deals with this very situation. And it's a difficult issue when you buy into an area such as this. And I know when you do spend a lot of money and you buy into an area like this, you don't go to Mr. Corcoran, who's a brilliant lawyer, and find out, what if I want to expand this place in 10 years? And Mr. Corcoran would say, I don't think you'd get a variance on it. That doesn't happen in real life. And you find yourself in a very awkward situation. I really feel, I don't mean to over-personalize this, but I feel badly for you, because I know you're acting in good faith. I know you're not trying to hurt anybody, but on the facts and on the law, this application does not have merit, and so I also intend to vote in opposition to this particular variance application. So all those in favor of the variance application, please say aye. All those opposed? So I'm very, very sorry that we have to deny your application for variance, but we appreciate you coming and we appreciate you trying. So we're going to... Thank you, Mr. Reed. So this meeting is adjourned.
So I gotta move here.
Oh, you're back again. Hello, how are you? Good. You make yourself comfortable. You take your time. What's that? Jenny. Mr. Dunn, are you all set on behalf of the applicants?
I am.
Okay, great. Welcome back to the board. Let me ask you, as a preliminary matter, do we have the same deal that we had in the previous hearings with respect to the court reporter? That the court reporter will be the official record of the proceeding. I'll swear the court reporter. You'll provide us with a copy of the transcript.
Yes.
If, as, and when, if it's ordered.
Yes.
Okay. Hello.
Hi.
Welcome back.
Thank you.
Let me swear you in as our official court reporter for the proceedings. Do you solemnly swear to fully and faithfully record the evidence at this hearing to the best of your ability, so help you God?
Yes, I do.
Welcome back to the Board of Appeals. It's good to see you again. Mr. Dunn, let me read a little bit of the application into the record, and we can then proceed with your application. This is the application of Philip Johanning and John Rowe, the appellants who live at 23 Parkwood Drive, Milton, pursuant to Section 9D of the Milton zoning bylaw and Chapter 48, Section 8 and 15. They're appealing their alleged inability to obtain an enforcement action from the Milton Building Commissioner. The subject property here is the Thayer Nursery property. It's located at 270 Hillside Street in Milton, Massachusetts. It's in a Residence AA district, and the applicants are contending that Thayer Nursery is illegally using the subject property as a site to receive and store bulk deliveries of kiln-dried firewood and to sell the firewood on a wholesale and retail basis from the subject property in violation of the Milton zoning bylaw and the Mass General laws. And they're here seeking an enforcement action from the Milton Building Commissioner because of what they perceive to be a violation of the Milton zoning bylaw. My name is John Leonard. I'll be acting as chairman for this particular hearing. With me for this hearing is, to my immediate left, is board member Virginia Donahue King, and to my immediate right is board member Brian Hurley. The rules of the board are going to be such that we'll hear from the applicant and any witnesses the applicant wishes to offer. We'll hear from any people present who may have questions of the applicant. We'll hear from people who are supporting this application for an enforcement action, and people who don't support the application for an enforcement action. So we'll have, as the official record, even though we're going to keep a tape recording here for the board's own purposes, we have an official court reporter present, which requires a couple of additional instructions from my perspective. And that is, the official court reporter is going to take down all of the evidence at this hearing, so it's very important that everyone speak up nice and clear and loud. Tell us your name and address before you say anything. And if you speak it 2 or 3 times during the proceeding, again, tell us your name because the court reporter may not be familiar with you. It's also important that you speak up nice and clear and distinct. Don't mumble. Don't nod your head. Don't make hand signs because that's not part of the official record. And I'm going to request our reporter here, if you have any questions as to what anyone said, just stop the proceedings and we'll get that down for you. If you if you feel that you missed something, don't hesitate to let us know. And likewise, if you think you need a break, I hope we're not going to go that long, but if you do need a break, don't be bashful, and we'll do everything in our power to accommodate you, okay? So, in addition to the advertisement, which I've read into the record, we do have the application of the Mr. Johanning and Mr. Rowe, to which is attached a November 1st, 2013 letter from Attorney Matthew Dunn to Mr. Prondak, our building inspector, and I see Mr. Prondak is there this evening. Welcome back to the Board of Appeals, Mr. Prondak.
Thank you.
So I think we did receive from Mr. Dunn a memorandum dated January 7th. It looks like it's attaching all the pertinent decisions, including the March 20, 2013 decision of the board, a decision by Judge Brian Davis in the Superior Court regarding an injunction, so, and some letters to Mr. Prondak, so you can feel free, they'll be part of the record, but you can refer to them to your content. We also did receive, and I want to be sure you received a copy of it, a statement in response by Mr. DeLuna. Did you receive that, Mr. Dunn?
I did.
Okay, great. Did you receive that just now, or?
Yes.
Okay, so you didn't receive it prior to the hearing?
No, and I just gave Mr. DeLuna a copy of my memorandum as well.
Okay, great. So if either of you gentlemen need to, time to read this or to respond to it or whatever, we can do it. Hopefully, we can finish this hearing tonight. I think that would be wonderful if we can do it, but if for whatever reason there are unanticipated arguments or additional evidence that you think that you want to offer, and if you had known what was in each other's memorandum, you would have offered it, just tell us, okay? We'll be happy to extend professional courtesies to you. So I think with all that as a rather long wind-up, Mr. Dunn, welcome back to the Board of Appeals. We're delighted to hear from you.
Thank you, and thank you for having me. I'd also like to thank you for coming out to Thayer's property yesterday for the site visit. I thought it was very helpful in helping us all understand the layout of the property and some of the activities that are taking place there. This is really a follow-up to a initial administrative appeal that was brought by my clients back in May of this year. As the board is well aware, this board in particular, we were heard over a course of 5 months on 3 separate occasions on basically the same issue that is at play presently in this administrative appeal, namely the commercial use of property in Milton's Residence AA District. As the board's aware, Section 3A of the bylaws expressly limits the use of real property in the Residence A to single-family dwellings with certain allowable accessory uses, and strictly prohibits the erection, alteration of use or use of any building or land situated therein for a store or shop or for manufacturing or commercial purposes. Now, we're all well aware that the Thayers obtained a special permit back in 1967 in order to operate a nursery business at 270 Hillside Street. And just to reiterate, as I indicated before this board on each of the 3 occasions that I was before it this year or back in 2013, that Mr. Johanning and Mr. Rowe aren't looking to shut down any business or run anybody out of town. The issue that they have with the operations at 270 Hillside is that the business has outgrown the parcel on which it's being operated. There's several activities that take place at different times throughout the year on that parcel. As we talked about over the summer, there's the landscaping and construction component. That was the subject primarily of your decision on September 26, 2013 of this year. That copy of that decision is attached as Exhibit C to the packet of materials that I provided to you. In that finding, or in your findings, you recognized that the primary use of the property was no longer for nursery purposes, and Thayer Nursery's own affidavit and financial statements indicated that that was the case. That finding has been endorsed and adopted by Judge Davis in his decision in the Superior Court on October 28th of 2013. So you have a parcel of property that has a nursery component to it, but there's also commercial activities that are not incidental or accessory to that. And the component that we're here to discuss tonight is the bulk sale, the bulk delivery, storage, and sale of kiln-dried firewood to that parcel. Now, Thayer Nursery advertises this particular component of its business on its website. I brought a copy of the website here, indicating that the kiln-dried firewood is delivered to the property and stored at a barn on the premises. Now, each of the board members were with the exception of Mr. Hurley, and I believe he indicated he was going to go by before the hearing today, were present yesterday and saw the barn and saw the quantity of firewood that's present in there. Now, that firewood doesn't appear by itself. It's delivered from vendors, various vendors off-site. My clients believe that it could be from Maine or someplace in northern New England, but it's delivered via 18-wheel truck. And this is a photograph of the 18-wheel truck that, one of the 18-wheel trucks that delivers the kiln-dried firewood to the barn at 270 Hillside. And as you see, it's an 18-wheeler, and this is parked directly in front. This photo was taken from my client's home, and it's parked directly in front of their property.
Is that a police car to the?
That's a police car, yeah. I don't know why.
Do
it's
you know what activity the police were engaged?
I don't, and I'm sure my clients would be able to educate the board as to what that was all about. But this is a photograph of the delivery truck that brings the firewood onto the property.
And when was that photo taken, Mr. Dunn, do you know?
Last summer.
Yeah, last summer.
Okay.
So
Can I stop you before you go on?
Sure.
You're gonna send us smaller 8x10 copies of
I
these
can, yes.
photographs, so we won't have to have these big charts.
Sure,
We
I'd be
can't
happy to
keep-
do that.
Okay, that's great. Thank you.
So my clients have indicated that these deliveries arrive or are made as early as 4:30 a.m. in the morning, in which case it remains dark, which requires illumination of the property, which is a picture. This is a picture taken of the backyard, taken from the back of the house, looking onto Thayer Nursery's property from my client's home at 23 Parkwood. And it illustrates the intensity of the light radiating from the property.
And when was that taken, and what time did you say?
This was taken,
In December, probably about 6:30, 7 o'clock at night.
once the property is delivered into the barn, it's loaded into dump trucks at the property via Bobcat and front-end loaders. The delivery itself from the 18-wheel truck causes loud noises as it's being dumped into the barn and moved into the rear of that structure.
Yeah, can I ask you something? Because we went there and we saw this huge barn, which maybe Mr. DeLuna will describe in a little more detail. But when the 18-wheeler filled with the firewood is being unloaded, do they unload it in a big pile in front of the barn, or can they back that truck into the barn itself and unload it in there, or how does that
Usually
happen?
they unload it in the yard and then the Bobcats
Bring it into the barn?
Yeah.
Okay. And then it's loaded onto trucks for sale to the public?
That it's loaded onto trucks for sale to the public, right?
Is it loaded in the barn or outside of the barn, or both, if you know?
Outside of the barn.
Outside. Outside of the front area of the barn? That's Mr. Joe Henning, by the way, who's the gentleman in the blue.
Okay.
And Mr. Rowe is the gentleman in the right. Okay, thank you. Why don't you proceed? I'm
No.
asking you too many questions, Mr. Dunn. Go ahead.
For one, the barn was constructed, I've been unable to find any building permits for the barn on the property. I don't know when it was constructed. I do know that inspection of during the site visit yesterday, it didn't appear that there was any fire prevention mechanisms that are utilized inside that barn. It stores highly flammable material, and it's our opinion that it's a safety hazard. But that's really an aside to what's the main issue here, which again is the sale of the bulk firewood. So in order to undertake this operation, the Thayer Nursery is utilizing equipment that is strictly or has been prohibited from being operated on the property pursuant to your September 26th decision, being the front-end loaders and the bobcats. Those aren't being used in connection with the nursery. They're being used in connection with the bulk sale of firewood. So yeah, I would say that those have already been prohibited by this board in its decision of September 26th. Now, again, we're not talking about small bundles of firewood that I think was what was contemplated as being incidental or accessory to the nursery business back in 1987. What we're talking about here is large cord-sized delivery of kiln-dried firewood, sufficient enough to fuel a home or to heat a home. And again, it's placed into large dump trucks on site using the bobcats, delivered off site. The location that we followed, one of the deliveries to was in Dedham, and it's provided to homeowners. As you can see, this is a Thayer Nursery truck to their home. That amount of firewood.
Do you have an approximation of how much firewood is in that particular truck? Is it
A lot.
1 or 2 cords? Or?
I don't know. I'm sure that.
We'll ask Mr. DeLuna when he gets up to bat.
But it's substantial. So on September 26th, this board ordered that Building Commissioner Prondak conduct a review of the retail sale items and goods at Thayer Nursery and issue any and all necessary orders that Thayer Nursery cease and desist from the sale of items and goods not reasonably incidental or accessory to customary nursery-related operations and not previously specifically authorized by a special permit previously issued to Thayer Nursery by the Board of Appeals. And that's language directly from this board's decision. Again, that's at Exhibit C, pages 14 and 15. That language can be found. We submitted no action was taken. I'm not unaware of any inspection that was undertaken by Commissioner Prondak in response to this order by the board. Regardless, we sent a zoning enforcement request to him. That's attached as Exhibit B on November 1st, asking that he conduct a review of the items because it's our contention that, again, that the sale of the firewood at this point is of such a size and intensity that's no longer incidental to or accessory to the nursery business, that this is really a standalone business, much like the commercial landscaping and construction business that this board has already prohibited. I received no response to my November 1st zoning enforcement request to Commissioner Prondak, thus obligating us to file this administrative appeal with the board. Again, Mr. Joanning and Mr. Rowe recognize that the 1987 amendment to the special permit allowed Thayer to sell firewood that was incidental to its nursery business. However, at this point, the operations associated with the kiln-dried firewood sales business on the property far exceed the size and scope of that contemplated in the 1987 decision. The business involves, again, the receipt of firewood from off-site via 18-wheel trucks, the use of front-end loaders and other machinery to load the firewood that's delivered to Thayer Nursery onto dump trucks for off-site delivery. In no way does it involve any of the nursery products that are sold on the property pursuant to the 1967 permit or any of its amendments. As the board is well aware, the Thayer Nursery is located in the Scottswood neighborhood, and Mr. Joining, this type of use is inconsistent with the residential character of that neighborhood, and is substantially interfering with their use and enjoyment of the property. Again, there's deliveries early in the morning, there's loud noises throughout the day while the trucks are being loaded. There's bright lights that are used in connection with the business that are operated early in the morning and at night that shine into my client's property. And again, it's causing substantial interference with their use and enjoyment of the property. As I indicated, I anticipate that there's going to be an argument made before this board, as there was on the 3 previous occasions that I was before it, as well as the argument that was presented to Judge Davis, that this use is somehow protected by the Dover Amendment. The Dover Amendment covers property that is primarily used for agriculture. This board has found on 2 occasions that that's not the case, those occasions being back in 2002 and again in 2013. Judge Davis has also made a similar finding, that the Dover Amendment is inapplicable to cover the commercial uses that are currently being operated on Thayer's property. That would include the bulk sale of firewood. It's not dissimilar from the landscape and construction activities, and it's not permitted in the Residence A district either by right or by special permit. If they want to do or undertake this type of commercial venture, they need to obtain either a use variance from this board, or they simply need to relocate to a different location. And there are several locations that are available to Thayer Nursery. To do that, it could cause a temporary inconvenience, but by no means should it put Thayer Nursery out of business. It's just they can advertise or continue to market this service. They just need to use a different location as a staging area, because it's impacting and continuing to adversely affect my clients' enjoyment. So for that reason, I'd ask that the board find in our client's favor to reiterate its findings of September 26th and order that Thayer cease and desist from the receipt, storage, and delivery of kiln-dried firewood, at least in the quantities and intensity in which they're currently operating, because it's not allowed under the bylaws, and it far exceeds what was contemplated in the 1987 amendment to the special permit that was issued to it.
Great, thank you very much, Mr. Dunn. Let me see if my colleagues have any questions. Mr. Hurley, do you have any questions of Mr. Dunn?
Not at the moment.
Okay, Mrs. Virginia. Okay. So, thank you. Do you have any other evidence you want to present? No, okay. So why don't we see if there's anybody present this evening who has any questions of Mr. Dunn or wishes to speak in support of Mr. Johanning and Mr. Rowe's application for an enforcement action. Okay, the record indicates there's no such person present. Why don't we see Mr. Delona? Would you like to be heard?
Please.
Good. Welcome back to the Board of Appeals, Mr. Delona.
Thank you. Just a couple of things to remember. Thayer Nursery has been operating on this site for many years, and permission to sell cordwood, whether it was needed or not, in 1997 was granted. And that was long before 2009, when the petitioners purchased their property. you heard repeatedly tonight, the word commercial use. One has to revisit Judge Sullivan's decision in the Von Jess case. And Judge Sullivan made it very, very clear that all agriculture is a commercial use. So let's not kid ourselves. This isn't a Walmart. This isn't a light manufacturing. This is agriculture. And Thayer Nursery is selling firewood as the special permit allows, and quite frankly, as 40A Section 3 allows. Approximately 20% of the product sold from Thayer Nursery is cordwood sale. That is far below the 75% allowed by virtue of 40A Section 3. So, commercial, yes. Agricultural, yes. Allowed by the statute, yes. Allowed by right, yes.
When you say 20% of the products, do you mean in terms of dollars, in terms of gross
Yes.
revenues received by Thayer Nursery? 20% is from the sale of firewood?
Approximately, yes.
Approximately.
Yes.
Okay.
So let's take a look at the application and some of the allegations, as fictitious as we believe they are. First of all, on the application, the barn's not located on Lot A. All right, small problem. All right,
Is it on, it's situated on
It's-
property that's owned or controlled by the,
it is.
by
but-
the owners of Thayer
But
Nursery?
not on Lot A.
Okay. Well, do
Okay.
you want to tell us what lot it's located on?
I believe
so
it's
we'll
on
have-
Lot B, or B1, I'm not exactly sure off the top of my head. Is it? B. B, thank you.
Okay, thank you.
Okay. It's not a DBA, it's a corporation. Duly?
Can I stop you and ask you a question about the barn?
Yes.
There was a reference in Mr. Dunn's presentation that the barn was built without a permit. Do you have any knowledge?
The permit is permit number 47206, issued on September 29th, 1993.
Okay, you're faster than I am.
I'm sorry.
42726?
47206,
47206, and it's
which was
dated
issued on September 29th, 1993.
29th, 1993. And just answer one more question if you would, because I just don't want a horrible thing. Is the barn equipped with fire eradication sources?
The building code does not require barns used for agricultural purposes, in particular storage, to have fire suppression systems.
Even if you're storing firewood in it?
Yeah.
Let me ask you, does good and prudent planning suggest that you may want to have some fire suppression resources in a
It's-
building where you're storing huge amounts of wood?
You wouldn't need to if you were a lumberyard.
See, I don't know that. You can tell me that. We'll ask Mr.
I
Prime.
mean, the expert's sitting over there, but as of the code is written right now, fire suppression is not necessary in an agricultural building. And again, I'll defer to the
No, that's
expert.
okay. We'll get to Mr. Prondak in a few minutes. I hate to disrupt your presentation,
No,
but I'd like to get some.
It's ad lib.
Could you tell us, it's never ad lib, we know that. It's a very skilled presentation. Could you tell us approximately the dimensions of the barn?
Ooh. I'll have to defer
Within 10
to-
feet or 20 feet?
40 by 80.
40 by 80. Okay, and how high is it?
14 feet to the rafter.
John, can you identify yourself?
Oh, I'm sorry, yes. Would you please identify yourself so we'll have it part of the record? Thanks, Brian.
Josh Oldfield, 24 Forest Street, Milton.
Okay. Thank you. Josh. I think.
Josh?
Oldfield.
Okay, great. So it's 40 feet by 80 feet, it's 14 feet high. And other than the...
It was built in 3 phases. Actually, I'm learning tonight it was actually built in 4 phases. It was originally built as a double bay greenhouse.
Yep.
All right, but the trucks could back into a double bay greenhouse. So that was converted to a shingled roof structure. Now, what's very interesting is if that building was in violation, it certainly would have come to the attention of the building department.
I'm not suggesting any violation.
No, this is important. This is important, because in 2005, there was a building permit issued, building permit 54395, for an addition onto this building. And the plans, and I can submit them, unfortunately, I only have the copy that was on file. The plans clearly show this as a shingled building, and the new addition matches the shingled building. So there's no smoke and mirrors, everything was done legitimately, and it was done in 3 phases. The first phase, which was, before we actually identified and found the permit records, Maggie tied it into, if I can say, when you were graduating college. It would be the early 90s. And the first phase, their father put in the concrete pad and the walls. And later, they put in the hoops, the arch structure, which originally was to accommodate plastic. So that's the first 2 years. And in the 3rd year, the plastic was replaced by a shingled roof. And the reason for that is Mr. Orfield, Robert Orfield, wanted to be able to back the large tractor trailer into the barn. He's paying premium money for kiln-dried wood. He's not going to take kiln-dried wood and store it outside. So they restructured it so that the trucks, the delivery trucks, all right, which are 18-wheelers, can back into the garage, into the barn, and deposit the wood inside the barn. And yes, they take a Bobcat and they load their own trucks.
It's on the website.
Is it on the
The
website?
website, yeah. Right there, yeah, the bottom.
If I may. Sure, yeah. Notice on the bottom, notice how the truck is? The truck that's being loaded is inside the barn. There's a reason for that. All the activity of unloading from the tractor trailer and loading their dump trucks, which, by the way, is not done by a front-end loader, it's done by a Bobcat, all occurs inside that barn. Now, the claim is that we're running a wholesale wood operation. I don't know how many of you burn cordwood. I do. I burn between 2 and 4 cord a year.
You're heating your house with...
No, I don't heat my house with it. I have a wood stove. 4 cord would not heat a house. All right? It's totally aesthetic. It's kind of nice to have a fire in my wood stove in my living room. 2 cords is not a heck of a lot of wood. One truck, the maximum, the largest truck they have, can only hold 2 cord. So it behooves me how they can say it's a wholesale wood operation. People are not heating their houses, all right, with this wood. They're using it exactly as I and probably you do, to supplement the heating, to add ambience to your house. The wood comes from Vermont,
All of it,
all of it. It's kin-dried
in Vermont.
in Vermont. That kills any disease, kills any insects. It's certified. It's produced pursuant to managed forests. The deliverer, the supplier, by Vermont code, cannot have his trucks running before 7 o'clock. So these trucks leave Vermont around 7 o'clock in the morning. It's approximately a 4-hour trip. They're not arriving at 4:30 in the morning. They're arriving around 11 to 12 o'clock in the morning. And when they arrive, they pull into the barn and they empty in the barn. This is clearly, all right, an accessory use of the nursery. With respect to the building commissioner not visiting the site, he paid a visit on November 25th, approximately 2 o'clock in the afternoon. He walked the entire site. He went into all the buildings. There were some items that we could not convince him that were agricultural, and those items had been removed. Nothing further said about it. It's recognized that the 1987 permit authorized them to sell firewood. I think I covered everything in my memorandum. Now, a couple of other things. Maggie, the other day, indicated with her memories, her father having her stack cordwood in pallets with various amounts. Would you like to describe what you'd have to do?
So for us to make any extra.
I'm sorry, this is Maggie?
Oh, Maggie Oldfield.
Sure, thank you.
237 Hillside. For us to make some extra money, my father said that we could stack some wood. And for us to do it, we would get a pallet, a regular plain wooden pallet, and go in and create different volumes of wood at different price levels. So if you wanted to come in and just get wood to watch a football game, you could spend $5 or $10. If you wanted it for the weekend, you could spend $20. And we would just set it right up in front of the nursery. And so now we're still continuing it the same exact way. We've replaced the pallets with metal frames that you saw on your visit, and it is a little bit more precise. It's an exact cubic footage, and it's a $20 rack, a $40 rack, an $80 rack, or a $140 rack. And you can pull in throughout the winter and load it into the back of your car. We still actually run on the honor system, so if we're not there, you can back right in, you can load it up yourself, and then you put the money in the box. So it's the same exact procedure as it has since we were children.
And what volume of cordwood, to use Mr. DeLuna's phrase, do you get for $20?
It's a 1 by 1 foot rack. So one high, one log by one log,
Okay, in the 40 is 2
2
feet?
by 2,
Okay, 2 by 2.
3 by 3, 4 by 4.
And 4 by 4, is that half a cord or a quarter of a cord, or what does that amount
It
to?
is
In terms of volume?
about an eighth of a quart.
Really? Okay.
It's 20 cubic feet. Most people cannot stockpile a lot of wood in their own properties. Most people do not, as Frank alluded to, burn wood to heat. It's mostly the smaller quantities.
So are you able to tell us, and I don't mean to put you on the spot, if you can't answer the question, just say you can't. But can you tell us how many, or what percentage of your firewood sales would consist of volumes of wood that would be 1 cord and higher as a,
Very few. Most of our wood, most of our wood is maxing out maybe at about a half a cord to a cord.
and what percentage would you say a half a cord to a cord?
If you know.
If you don't,
Yeah, I
okay.
don't know
Could,
that.
if I ordered a half, I know very little about firewood, but if I ordered a half a cord of wood, would that be too much to put in my automobile?
Yes.
Yes.
So I'd need a pickup truck or something.
So if you were to stack a half a cord in your garage, which you can only do with kiln dried because it is insect free, so you can store it in your garage, it would take up a space of 4 by 4 by 4. So 64 cubic feet.
Okay. And
Most
so,
people don't store kiln dried outside because, as Frank alluded to, it is a premium product.
sure.
And,
In their garages is such a mess, they can't put that much wood inside their garage.
yeah.
So they have to buy smaller volumes.
Mhm.
Okay. So most of these sales are a half a cord to a cord, and they're delivered in your dump trucks, is that true?
Yes.
And are most of your sales in the town of Milton, or is it, what percent are the town of Milton, and what percent is the surrounding cities and towns, if you know?
That I don't know the percentage.
But the smaller the sales, the $20 and the $40, which I'd probably be a candidate for, you just pull in and open up the trunk of your car and fill it up,
Yeah.
and maybe put some wood in the back seat and drive it out.
Correct.
Again, Josh Oldfield, 24 Forest Street. We've developed quite a following for this because people do appreciate the honor system, and we've been doing it as young children. So there wasn't that old feel available, and now people really appreciate the fact that we do that. We control the hours of when people can, we have automatic gates
I saw that.
at
They're
an,
not automatic.
well, they're electrified, and I live next door, so I control when they open and close. Generally during the season, earliest they'll open is 8 o'clock, and the latest they'll close is 5 on my way home.
If I purchased the $80 volume, the 3 foot by 3 foot, would that be too large for an ordinary motor vehicle? Would I
No,
need a dump truck for that?
no.
I wouldn't.
No, 4 by 4,
Even the largest rack that we sell could still probably get into an SUV.
oh, definitely an SUV.
Okay, but not
Possibly
not
a station
passenger.
wagon.
You might limit your suspension on something.
Correct. It comes down to what you can hold weight-wise. It's not a safe.
Let me ask Mr. DeLuna a question, not to put you on the spot, but can you tell us approximately per season how many cords of firewood are purchased from the Vermont resource dealer and how many are sold?
We had that number approximately. Can you recall?
Every year is slightly different because of the weather.
Okay, let's take this year.
So this year, we get approximately 1 truckload a week. And each truckload holds, each 18-wheeler holds 17 cords.
Okay, and what would be the time frame within which you'd purchase one truckload per week?
Starting mid-September, going through mid-March.
Again, Josh Holtfield, 24 Forest Street. In reference to Mr. Dunn's photos, if you look at that truck and the time of year that they propose that that truck was delivering firewood is incorrect, just by looking at the leaves on the trees. It's a clear indicator that it was not a fall delivery.
Sure. Let me ask you this, since the firewood is approximately
winter.
20% of your business, and when you start to get into the fall, would you say in that September, October period or November period, you tend to stock up more than one truck a week of firewood to build up a reserve in the barn, or do you just keep it consistent?
We keep it consistent. What it is, it's an inventory control mechanism for us. It is a natural product. It has a certain amount of
Shelf life.
dust and debris on it.
Okay.
And if you end up stockpiling too much, putting one truckload on top of another truckload, you end up with a dust problem. Not necessarily on our end, but for you, when we deliver it to your house, you would end up with a lot of dust and debris. And because you're paying more, you then would call us and say, I don't like the delivery. I got a lot of unusable material in it. So what we like to do is we like to empty the barn as much as we can and sweep it out. And so then you're getting the cleanest wood that we could possibly deliver.
Okay. Good, thank you. Mr. DeLuna, have you completed your presentation, or do you have something else you'd like to add?
Josh mentioned the truck there, that it's inconsistent with when they buy or they purchase wood. The second thing is the nighttime shot that you saw. That's 6:30 at night. A, that's within the operating hours that the board has set for the nursery. And B, there's no indication that that is even a wood truck. It's completely inconsistent as to when wood would be delivered to the farm. So, I mean, I think we've given you a demonstration or a synopsis of how the wood operation occurs. It's clearly within the 75% of the other product. Is it commercial? All agriculture is commercial.
Not from Massachusetts.
It doesn't.
Unless you're applying the...
It doesn't, if the 50% goes to the Massachusetts product. Remember, 48 Section 3, you have 25% your own product during the principal growing season.
None of this is, we're talking about firewood, none of this is their own firewood.
None of this is their own firewood.
And none of it's from Massachusetts, it's all from Vermont.
That's correct. As it,
Unless we're going to apply the...
the 25-50% rule, then it doesn't count, yes. That's what happened.
I
with
threw
that
you
lip.
off, I'm sorry.
No, that's
to have done
okay.
that.
The decision. The court made findings, but the court clearly said in its decision, these findings are at this point of time.
They're preliminary.
It's just the preliminary. So the discussion as to what the court has found, all right, is inappropriate. For the purposes of the injunction, the court made those findings. But those clearly, as you know, are not final findings. There's a whole trial yet to be done.
Well, I'm sure of that, and there are whole appeals to be done after the trial, but we understand that. Let me ask my colleagues. Mr. Hurley, do you have any questions of the old fields of Mr. DeLuna?
Could you describe for me what the firewood operation was like in 1987?
I wasn't around, I'm sorry.
Maybe one of the old fields can. How was it different from today?
It was actually outside, so we did not have a barn. And originally, we sold seasoned wood. My father sold seasoned wood, which means that the wood just sits out to age naturally. So that was in a big pile outside. And then once he discovered the kiln dry, we then had two piles. We had a pile of seasoned and we had a pile of kiln dried, because there was a price difference. We wanted to give people a choice. And once people tried the kiln dried and saw how much better product it was, we stopped selling seasoned completely. But all the kiln dried was still outside. And what we had to do is put a tarp over it. And that was a major pain, because in the middle of the winter, when there's snow, then you're taking the tarp has the snow on it, so it became like kind of a nightmare, you know, to operate. The truck would come in and deliver it, and it would not be in a building, it would just be out in the parking lot. It was on a gravel driveway.
Same size vehicle that we get today.
We've been buying from the same company. We were like their first client down here. And it would come in, it would get dumped just on the driveway. We would load it up in the open so the noise wasn't being minimized. So it kind of was possibly even a little bit louder back in the day.
What was the volume of wood sold in '87 as opposed to today?
Well, to be honest with you, it was more
Less
because
competition.
we had less competition. Now,
I don't mean to suggest that I have an answer in mind when I ask the question.
So unfortunately-
I have no idea what the answer is going to be.
unfortunately, I wish I could tell you that our sales volume have increased dramatically in 25, 30 years. But because of the competition, it hasn't.
Speaking of competition, if I may add, attached to to Maggie's and Josh's statement, you'll find a series of nurseries. And those nurseries all advertise firewood as a product that they sell. And I did specifically look at nurseries as opposed to farms or wood cutting operations. So it's very clear that in the nursery industry, the sale of firewood, cordwood, is an integral part of their sales structure.
And also, just as a note, when I was talking to our supplier, as I said, we've been buying from him forever, and sometimes we would like to buy more from them when the demand is there, but they themselves are under strict guidelines up in Vermont. Vermont has very strict environmental laws, and when I was talking to Christy, she referenced this Vermont Act 250, and her Vermont Act 250 permits limits the hours of their operation as well as the length of their operation. I believe, and I don't know for sure, but I think they can only kiln dry their wood from August to April. So it's a very small window, and they can only sell and produce so much wood.
And you'll find that in there's a Colton Enterprise in the package that we gave you. The last paragraph talks about Vermont Act 250. And there's a synopsis of what they're actually selling behind that.
Could I ask you a couple of questions about your exhibits? You have 5 or 6 or 7 examples of nurseries that sell firewood, but none of the examples are within the town of Milton. Is
No,
that
they're
true?
not. That was just an example of what a classic nursery does sell in Massachusetts.
And that's all you're intending it to
That's
be?
all, yeah.
Because there's no representation or evidence, to the best of my knowledge, that any of these nurseries are in high-end residential districts.
Eagle Farm.
Eagle
Milton.
Farm.
Here in Milton. But
yeah.
Mahoney's,
Oh, no, I'm talking about that's attached to your,
well, Mahoney's
Mahoney's
is in
is in
Winchester.
Winchester.
I'm pretty sure that's a little bit more high-end than Milton.
right, I mean,
Katomet, down the Cape, they sell firewood.
and that's in a residential district?
I don't know if that's residential, that's on, I think that's 28A.
Russell Farm is on the Reading-Woburn line in a residential
Right,
district.
but Russell Farm, I mean, the photograph here makes Russell Farm look like it's your source of firewood. I mean, it looks like it's 5 forests that have been chopped down and turned into kiln-drying firewood.
Well,
Is it true, to the best of your knowledge, so we can come closer to home, that none of the nurseries that exist in Milton store their firewood on site, even though they sell firewood? They don't store it on site?
I wouldn't know that.
And that only your client stores it on site in a residential area?
I wouldn't know that.
You don't know that. Did you know that most of the nurseries in Milton do sell these small 20 by 20, 1 foot by 1 foot packages of firewood, but they don't truck it off-site?
Supermarkets sell that too.
They do, that's what I mean, yeah, supermarkets do it as well, for people who want to have a fire or two.
Believe me, I couldn't afford to light my fires by coming out of a supermarket.
Well, that's because you get a deal from your client. I certainly hope you do, for all the work you do.
No, I
Paula.
split my own.
You do? You probably do. Okay, Mr. Hurley, I don't mean to be humorous here. Do you have any further questions?
That was all I needed to know.
Okay, Mrs. King, do you have any questions of
I
the
do.
Oldfield?
In
Mr.
reference to the picture of the semi on Parkwood Drive, I know that you had made reference that it was probably out of season, but I was wondering what that was doing there.
I don't know exactly, because I don't know,
We don't even know if it
if
was
it
a
was
truck
coming to the
Fay
nursery.
nursery.
We don't know that, if we knew the date, and.
Do you know what the police car was doing out there?
No.
Was he
No.
arresting the, pardon me?
I called them.
Oh, you did, okay, all right.
Oftentimes trucks, if they're backed up with deliveries at Thayer, they'll park on Parkwood Drive because the other roads are too narrow.
That's Mr. Rowe speaking.
Actually, what happens more likely than not, a lot of truck drivers now, as we all do, we all use GPS. And if a truck driver puts in 270 Hillside Street, what happens is they're all coming from 128, so they all come down past Houghton's Pond. So when you come down past Houghton's Pond onto Hillside Street, to get into the nursery, you'd have to take a right onto Forest Street, and truckers can't make that turn. So what they do is then they go up to Parkwood, and they have to turn around. Even though we tell the drivers and the growers specifically to come down Route 28, they put in the GPS. So that's what could have been happening. They could have gone into Parkwood and just turned around, because there's no other way to make a U-turn.
But for the purpose of firewood, that's not a firewood truck.
Right.
Oh, you see, that truck was hauling something else?
Yeah, that's-
Possibly,
Yeah,
but
it's not a
Oh,
fire truck.
okay, so that's not the type of 18-wheeler that customarily brings the firewood to you from Vermont?
no, that's a longer trailer.
That's longer than the firewood trailer?
Does that have vinyl sides?
Yes.
Yeah, that's a nursery stock
A
trailer.
vinyl sides would never hold firewood, so it clearly wasn't a firewood truck.
Good. Mr. Delona, do you have anything else you'd like to add?
Not at this time.
Okay, let me, I've asked the panel whether they had any questions. Is there anybody else out there who wishes to be heard on this enforcement action? Yes, sir.
Dr. Martin Dunn,
You want to come up here, Mr. Dunn, so you'll be...
I just have a question, a brief question. Dr. Martin Dunn, 50 Briarbrook Street, Milton.
Good, welcome back to the Board of Appeals.
Thank you. When was this photo taken of the truck? What time of year, not the date of the year? Not-
There are truck deliveries, I believe, 12 months out of the year.
Yeah.
And we get truck traffic like that.
Yeah. The point I just want to make is build a home right directly across from these two people, that was on fire a year ago this time. And they just started demolishing that. And there were big trucks down there all the time loading. So they raised the building completely, and now they've just poured the foundation, and now they're starting to build again. But there are a large number of trucks in there. I have to go right by that in order to get to my home. And so I have to very cautiously go down that area because there are trucks there. I just want to make that
Great.
that point.
Good, thank you for coming, and thank you for being heard. Is there anybody else who wishes to be heard? Yes, I think maybe one second, let me just defer to Mr. Prondak. And Mr. Prondak, do you want to be heard here on the question of firewood only?
I do.
You do? Okay, then you certainly, why don't we hear from you?
On the question of firewood, I did do an inspection at the site on November 25th. I did view the firewood barn and receive information as to how it was used, much as what you heard tonight. It was also explained to me that when the tractor trailer backs into the barn, there's some sort of a moving bed or something, so that it doesn't dump like this. Somehow there's some sort of
The live bottom bed.
Live floor, they
Like a
call it.
conveyor type?
something like that, and that's how the firewood gets out of the truck. So during that inspection, I did view some products that I believe were not consistent with what's allowed by the previous decision. I made note of those. And I prepared a memo and sent that to town council, seeking opinion on some of the items, some of the minor items that I felt were not consistent with the board's decision. But primarily, I looked for an opinion from town council as to whether or not the firewood was protected by the Dover Amendment. I do believe that firewood is an agricultural product. My problem, or my question, really is when you have a particular agricultural use and you're allowed to, or the quota, so to speak, is that 25% of the product has to come from local Massachusetts farms, and the other 75 can come from other sources. It seems to me that that should be, in this case, nursery products. So my question really to town council is, does the firewood by itself have to hold to that? Does 25% of the firewood have to come from local sources, and then 75% can come from out of state? Unfortunately, I have not yet received an answer from town council. That is unfortunate, although it's not unusual. Whereas this action has come in front of the board prior to me receiving advice from town council, I will defer to the decision of the board, whatever that may be tonight. And that pretty much
Okay.
sums up my input.
Mrs. King, do you have any questions of Mr. Prondak?
No, I don't.
Mr. Hurley?
Mr. Prondak, before you went out there to do your inspection, I mean, you knew already that they sold firewood there.
I did.
So it wasn't you going out, I thought at least by the decision, to see whether there were additional products that hadn't previously been identified that might fall within the purview of the board's decision.
Since I'm not sure if you understand your question, but let me say this. Since the board's decision, there was an additional request from, I believe directly from Mr. Johanning, and then followed up again by Mr. Dunn, that I specifically take a closer look at the firewood
Gotcha.
during my inspection, and that's...
That's all I have for
Okay. Mr. Dunn, did you want to be heard further?
I do. I just want to, I think we started to sort of float away from what the, what the main complaint is here with respect to the administrative appeal. And that is that like the commercial landscaping and the construction business that was the subject of the previous hearings, the intensity of the use has increased beyond what it was in 1987. We're not trying to shut down what Ms. Oldfield was talking about, people coming by to pick up their 2x2 and 3x3 and 4x4 stacks of wood. That's not what we're talking about. Since 1987, you've had the construction of a barn, you've had a different delivery source of a different type of wood, a different delivery source for the wood, and you've had a different delivery method with regards to how that wood is distributed to the general public. Now you're having dump trucks filled up with cord-sized, 1 and 2 size cord sizes of wood being delivered off-site to various locations on the South Shore. This isn't what was going on there in 1987. To make this very simple for the board, you're in the Residence AA. The Residence AA says you can't use property for commercial purposes. This is clearly a commercial venture, and by the word commercial, I don't mean, we're not talking about wholesale or anything that Mr. DeLuna was talking about. We're talking about a for-profit business, and I don't think there's a question that that's what's happening here. There's a for-profit business being operated, and how can that business be operated in the Residence AA district? Is it incidental or accessory to something that's permitted there? And what is permitted there? A nursery is permitted there. How in God's green earth is the sale of firewood at this intensity incidental or accessory to the nursery operation? The only thing that I can come up with is they both involve wood. One is a tree, and one is wood, kiln-dried firewood that's sold and delivered in a dump truck. I mean, one doesn't have anything to do with the other. So it's not accessory and incidental, and I think you're really stretching the bounds of logic and reason to try to make that connection, because it doesn't exist. So if it's commercial and it's not incidental, then it's not allowed in the Residence A, at least not in the level that we're talking about here. I mean, you have, based on my rough math, and I'm horrible at math, but Ms. Oldfield said that they have, for approximately 7 months, they get 1 truckload of wood delivered per week, and 1 truckload is 17 cords. So that's 7 months times 4 weeks, so that's 28 cords of wood, or 28 deliveries, times 17. I have it's 476 cords of wood that's delivered annually to the property. That's a lot of wood. And, that wood isn't being picked up, by the 2 and 2x2 and 3x3 and 4x4. That wood has to be delivered by the dump trucks that are coming onto the property. And the intensity of that use is just, it far exceeds what is reasonable for the Scottswoods district and for that residential district. And for that reason, I'd say that, some limitations and restrictions has to be placed on this type of use.
Good. I have a question for Mr. DeLuna. Mr. DeLuna, are you able to help us? We established at the first 3 hearings on this application that the primary income from Thayer Nursery had been landscaping and construction, and that the nursery had decreased in volume, okay? We have the cord wood being 20% of the gross sales. That's been the testimony here, okay? What percent, do you know what percent of the gross sales is part of the nursery business? Forgetting the sale of firewood, but the sale of plants and flowers and traditional nursery product excluding firewood.
Want me to answer?
Hold on 1 second, let me see what we had. Go ahead, you can answer. We submitted that information at a prior hearing.
Right, so, the 20% that I referenced tonight is strictly off of nursery sales, has nothing to do with landscaping. Because in our mind, you guys have already ruled on landscaping, so I've taken out the sales of any landscaping items. So the 20% is not, so we have two portions of our business. We have the landscaping division, and we have the nursery sales division. So you guys have ruled that our landscaping is a separate entity. So for tonight's meeting, that 20% is I took the total nursery sales, excluded anything from landscaping. So it's not 20% of the overall Thayer nursery sales.
Well, that's what I asked, and somebody said yes. I asked whether it was 20% of the gross sales of Thayer Nursery, and the answer was yes.
Yeah, of the nursery.
But I recall that the landscaping and construction, I thought was 45% of the gross sales.
And
And if that was so, and the nursery sales had fallen off over the years,
And
and you got 476 cords of wood, it's an enormous amount of wood.
first of all, 476, that's a rough number.
Sure it is, but it's a lot of.
And in the beginning of the season, we're not getting a truckload a week. Correct me if I'm wrong.
Correct. And it's not a 7-month season because of the Vermont Act.
So it's.
Right, but you're telling us that 80% of the nursery sales of Thayer, 80% is the sale of plants and things, and only 20% is the sale of firewood?
Yes.
That's your evidence.
You were in, understand.
That sounds crazy to me, and you'd be right, I don't know, I'm not in charge of.
I don't have,
If you look at our actual percentage of firewood sales, the percentage-wise would be decreased if you add in the sales from landscaping. So I've taken that out.
Okay.
the number that she, and I believe we gave this affidavit at the last hearing,
We have it,
breaking
it's
everything
in.
down. And it's remained a little bit more in wood sales this year, but it's pretty consistent with Maggie's prior affidavit. What I was looking for is, I was gonna submit an affidavit, but it's covered in the memorandum, so I'm not.
Okay.
But I had backup information, I don't have it with me. But what Maggie did is took the nursery sales, not the landscape
Yep.
business, just the nursery sales, and calculated the dollars generated by the sale of cordwood versus the dollars generated by the totality
Of the nursery sales.
nursery sales.
Okay, and the firewood is 20% of that number.
Correct.
Okay. You all right with that, Brian?
Yeah, I
Okay,
understand.
okay, fine.
A couple of things, if I may. Maggie, Josh, your dad sold firewood by the truckload as well?
Yes.
All right,
And,
so,
like we mentioned, we sold more than, Mr. Dunn was not listening. There was competition in the day, so he's saying that we're selling more. But he obviously didn't listen to what we said earlier.
And I don't know what he's basing his facts on, because we've never presented.
Respectfully, that's actually not what I'm saying. What I'm saying is that the intensity of the use, I'm not saying the quantity of the sales. I'm saying, did your father use back-end loaders to fill dump trucks
Yes, he
with?
bought the first Bobcat in New England.
Okay, covered in a barn. I mean, I don't want to make this.
No, no,
It wasn't not
Okay.
covered in a barn.
Okay.
We already said that.
I understand what you're saying.
with respect to whether or not firewood is an agricultural product, I refer you to Mass General Law, Chapter 128, Section 1A, which is the statutory definition of agriculture, which includes forest products, which this is. The letter in our file that I tendered to you clearly demonstrates that this product is taken from managed forests
In Vermont.
in Vermont, yes.
All right. Let me, Mr. Dunn, your clients earlier were waving their arms as if they wanted to be heard. Okay, so they don't want to be heard.
I do not.
Okay, thank you. Mr. Rowe, you don't want to be heard either? Okay, great. So if nobody else has anything to say, if the board has no questions? Good, we'll end the evidence at the hearing at long last, and we'll consider the application right here and now. So, Mr. Hurley, do you want to be heard?
I'd like to wait to hear what others have to say.
Okay, Mrs. King, what do you have to say?
I'm pondering still.
Okay, Mrs. King needs some time. So let me start the discussion, and we'll see where it goes. I guess based upon the comments of my colleagues, it's pretty evident that we don't discuss these things in advance of the hearings. So let me start out by saying, first of all, thank you, Mr. Dunn, for your excellent presentation. It really was an excellent presentation, and your materials have been very helpful to us. And Mr. DeLuna, always, this is an area of specialty for Mr. DeLuna. He represents a lot of people in the agricultural business, and we always appreciate his insights and his experience in this area, and he's done a wonderful job making his presentation. The way I look at this is I went back to some of the earlier decisions of the board, in particular where firewood wasn't an essential or primary consideration of the board, but it was an incidental consideration of the board, and the board was more concerned with the sale of nursery stock and the effect on the neighborhood and all of that, and how back in 2000, a little nursery was growing very, very big and was very, very successful because everyone has the greatest respect for the Oldfield family and for your dad, who was a legend in the business and a wonderful, wonderful guy. And the board at that time decided to regulate the nurseries, Thayer Nursery in particular, but the nurseries in general in Milton, under the special permit process, thinking that we could give a little here, take a little there, try to make everybody happy, keep the neighborhood residential, yet allow the nurseries to thrive and be successful, and that somehow over time we could regulate these businesses, not by granting variances which run with the land. You get a variance, the variance, if it's a valid variance, lasts forever, but special permits are revocable, they're adaptable, they're modifiable, and the like. And so the board, for a period of 10 to 15 years, maybe a little bit longer, went through the tortured process every 2 or 3 years of trying to anticipate the effect of this nursery and other nurseries in Milton on the residential neighborhoods that they were abutting. And some of these earlier decisions, which I did read, specifically did allow the sale of firewood, but it doesn't go into any particulars as to the nature of the firewood, the amount of the firewood, because it was incidental, I think, to the decision of the board. But what the board did in these decisions is the board suggested that all of the limitations and safeguards in these earlier decisions were always modifiable because the target's always moving, the business changes. Mr. DeLuna made a wonderful presentation at the at the last hearing about the changes in the nursery business and how the nursery business has morphed a little bit into the construction business and into the landscaping business, and it's part of the growth of the landscaping. It's part of the growth of the nursery industry, which he's seen for 20, 25, 30 years, and he rightfully cautions that you have to be very careful in analyzing these cases by reading 1995 and 1997 decisions, because the act is always being changed by the legislature, and it's certainly not enormously clear what the legislature intends many times when it makes amendments to the so-called Dover Amendment. But the intent of the board was to try to work with everyone and make everybody happy and to try to comply with the zoning bylaw. until we had the last hearing, and we have Judge Sand's opinion, which indicates that landscaping businesses and construction businesses are not allowable by variance, by a special permit under the specific zoning bylaw of the town of Milton. And in fact, he finds, just as Mr. Dunn argued in that earlier proceeding, that you needed a use variance to do that. And so when I kind of look at this case, you know, I see it's kind of a moving target, and I'm not specifically sure what type of sale of firewood was intended back in 2000 or 1997 or whatever. But we see what has happened is the landscaping. I think what we see here is the landscaping equipment and the trucks, which were at least formally in the good weather, were being utilized in the construction business, which has been not permitted by this board. You know, it is being used as part of the sale of the firewood business. And I certainly take Mr. Dunn and his clients at their word as to the noise and the times of deliveries and the adverse effect which it has on their particular residents. It seems to me that I understand that firewood has an association with agriculture, but I don't know how the sale of cords and cords of firewood, which are imported from the state of Vermont, has anything to do with the Massachusetts Dover Amendments. I mean, nothing's grown on site, nothing is, it's a commercial venture. It's not fostering agriculture in Massachusetts to the slightest degree. So, and except Mr. DeLuna's experience in this matter, but it doesn't seem to me to tie in to the Dover Amendment. And so therefore, it ties in more to me to a landscaping and construction aspect of the business. And I take Mr. Joe Henning at his word that he doesn't want to put their nursery out of business. But all of the nurseries in Milton that I've seen don't have their firewood on site. You can buy 10 cords of firewood at Eagle Farms or at Thomas Nursery. You pick up the phone and they have it delivered from some off-site source. At the same time, I know you can go to Thomas and you can go to Eagle Farms and you can buy small quantities of firewood just like you can buy on your barn, in your barn. I don't even think they do it on the order basis as you do, because you've got long-term respected clients. And so it seems to me that certainly the 1998 decision or the 2000 decision, which may have talked about firewood, certainly didn't contemplate 18-wheel trucks coming in week after week after week after week, and then being hauled off and delivered all over the place as part of an agricultural operation. I don't think it is. I think it's more applicable to a commercial construction type business. I can't tie it into the zoning, to the Dover Amendment. I think if I want to drive into Thayer Nursery and fill up my trunk with firewood and drive it away, Mr. Dunn and Mr. Johanning don't object to that. And so I think it's a question of maybe drawing the line somewhere and permitting the personal use of firewood that can be taken by individual consumers. Presumably they're not driving big trucks onto the property and they load their trunks or their SUV with $20, $30, $60 worth of firewood. They probably load that themselves. You don't need mechanical equipment. And to drive off and allow Thayer to make money on that. But to me, it seems as if the large, if I wanted to buy 1 cord or 4 cords from Thayer Nursery, as I'd love to do, should be delivered from some off-site premises, so it's not adversely affecting the neighborhood. So I'd be inclined on this one to allow certain amounts of firewood to be sold to individuals, but not trucked off of the site. And I think just like the construction wood, the mulch, all of that stuff, it should be done off-site in a non-residential area. And I know how awkward that is. I know you're trying to find a place for your equipment to continue your construction business. To the best of my knowledge, every nursery in Milton has done that. They've taken any construction equipment, they've taken it off-site, except as it's incidental to the nursery business. They've taken their ties and timber and stone, they've taken it off-site so it doesn't affect, and they're still in the business, and they're still making money, and it may be an adjustment for you. But I don't think that our earlier decision, the Dover Amendment or anything else contemplates the type of intense commercial sale of the firewood that's taking place here. But I'm delighted to hear from my colleagues. Mr. Hurley, what do you have to say?
Well, in the last case, I was never persuaded that the landscaping business was protected under the zoning amendment, and it didn't have a specific permit ever granted in favor of that use. And so they had to rely on it being sort of incidental to previously permitted use, and I never thought that they made it on that issue. So that was why I felt the way I did about that last decision. I think this case is different. In 1987, the zoning board of appeals gave them a special permit to sell firewood. They didn't put any limitations on it. The only evidence that we have before us tonight is that the operation, apart from the fact that there was a barn, that there's now a barn, was fundamentally the same as it is today, and indeed the volume was greater. All the wood came from off-site. It had to have been delivered today by trucks. It was taken off-site in the same kind of trucks that's taken off-site today. So I don't know how we get around the fact that that special permit was issued. To me, that's a fundamental
Well, Judge
distinction.
Sands said we shouldn't have issued any special permit for any type of use.
But it was
because
issued, and
It
no
was,
one ever
and it's
appealed.
invalid. The judge ruled it's invalid.
Well, I don't think you can rule a 1987 special permit to be invalid. I don't think that's our place to do that. It was granted in the use, and the only evidence before us would suggest that the use is virtually the same, with the exception of a barn, which sounds to me like it ameliorates rather than exacerbates the situation as it relates to wood. At least that's the testimony that's been before us. On the 48 section 3 part, I have to confess that I didn't study that before I came here tonight. I don't feel particularly comfortable in reaching a decision on that without actually looking at it. And I would welcome some additional briefing from Mr. Dunn and Mr. DeWinter on that issue. I think that's an important issue. And I don't feel comfortable reaching a decision on that point tonight without at least having an opportunity to study it a bit more. I need to look at the statute and the cases to see what they mean about the 20 and the 75. I'm just not prepared to do that. But I'm troubled by the 87 special permit. It was granted, it wasn't appealed. I don't see how we can just ignore it. And I think that makes it different than some of the other businesses in the town who I don't think had the benefit of a special permit to sell firewood at the site. I don't think Eagle Farm did, as I recall, when we considered some of those issues. So, I mean, that's my sort of preliminary thinking.
Okay. Mrs. King.
I don't have much to add to it. I know that there's been issues related to some of the more, I'll say, industrial uses of this commercial property, or not commercial property, residential property, but using in a commercial way. I know there have been a lot of complaints over the years, certainly going back to the early 2000s. I realize that's another 13 years after this special permit that we're referencing. And so I guess I feel like I need more evidence on what exactly was sold in the 1987 timeframe compared to now as far as wood goes, and what the operation was. I know we've taken some testimony on that, but I don't have anything to back that up with my decision, and I do feel that I need to do that. Because certainly if there was evidence to show that there was more firewood being sold, certainly we would need to rope that in, because it does appear that it's something that's not contemplated in 1987. But we have some conflicting evidence on that, so I would like something a little bit more firm before I can make a decision on this, and I guess that's where I'm going to stop talking right now.
Okay. It seems to me that we're in a position here where we're not prepared to make a decision tonight, which is fine. I honestly don't know, going back to 1987 and finding out what happened in 1987 as compared to the present time for a use that doesn't seem to be agricultural, and doesn't seem to be permitted under the special permit provisions of the bylaw, what evidentiary value that has. But I agree with Brian that in a sense, we probably should take more evidence on, or certainly legal arguments on the Dover Amendment aspect of this. And Mrs. King would like more evidence on what type of activity was taking place in 1987, and she's entitled to that if she needs that to make a decision. So I guess we need a continuance date here.
To reopen the public hearing again? In other words,
Well, we have to reopen the public hearing if we're going to take additional evidence, whether it's in affidavit form or...
I would like to see very specific information in an affidavit form about sales and percentages and all the Dover Amendment related stuff. It's a complicated subject. I promise you I will read the statute carefully in the cases before the next public hearing. But I'd like to see that factual predicate. I mean, we've talked very generally about it, but I'd like to know. And similarly, on either side, I'd like to see affidavit testimony on what the nature of the use was in 1987. To the extent that you can find that information, I at least would find that helpful.
Right. The only problem that we have is that puts Mr. Dunn and his clients in an unenviable position, because they didn't buy this property until in 2008 or something like that, and so we can get affidavits from Thayer Nursery, but they're not going to have any idea as to what the business was back in those days. They never even lived in Milton.
So what do we do about that?
We take the best evidence that we can and we use it.
I mean, I don't think you would want us to, my understanding is this would have to be unanimous vote to overturn the building inspector. This would have to be unanimous vote to compel the enforcement here. And if you...
Well, I'm not sure that's true, because we don't have any enforcement action by the building commissioner to determine whether he's taken no action on this.
I think it might still be a unanimous vote then, with respect to his no action.
To order him to take action. Okay, that's probably true.
And if you forced me to vote tonight, I would vote no. So I think, I'm not trying to be difficult here, but I think we ought to give everybody an opportunity to make their last best case on this. Another issue that troubles me that hasn't really come up tonight is this wood issue was part of the last enforcement action. If you read the
It was.
enforcement
It was.
request, and somehow or other, it just kind of faded away through the process because we do not address it specifically in the decision.
Well, we do, in the limited sense that we said the primary consideration in the last 3 or 4 hearings was dealing with the landscaping and the construction business, and that was the primary concern. So we directed Joe, Mr. Brondek, to go out and look at the other things that were being sold at Thayer Nursery to determine whether they were reasonably incidental to the operation of a nursery and whether furniture is or birdhouses aren't. And we entrusted that discretion to the building inspector.
I didn't draft the decision, but I didn't read it, and I didn't understand it to mean that that included wood, because we knew they had wood out there. I thought the purpose of that was to send them out to say, see what other stuff they have out there, and you tell us whether that other stuff that we don't even know about is incidental.
Well, some of the stuff we did know about. We knew they were selling furniture. That doesn't sound incidental to me.
No, but that's not my point, though. I mean, we knew about the wood issue, and we didn't specifically say in our decision A&A on the sale of firewood. I don't think we left that to Mr. Prondak to decide.
Well, I think the question was, it was never, I don't think the sale of firewood was a significant issue in either the first, second, or third hearing. I don't recall any significant evidence or complaints about the firewood operation, but I could be wrong. I'd have to refer to the transcript. I don't recall it.
I agree.
Well,
In fact,
but
I
what I
reached the
do-
point where I thought it had been waived, frankly, because it started in the initial enforcement. It was specifically addressed. It was part of the enforcement, stopped them from selling firewood. And then it just kind of faded away. My point in all of this is, it's certainly possible that one could argue that the firewood issue should have been appealed by the applicants, and that they've waived that issue as a matter of law by failing to file an appeal under 4817 because we didn't enforce that aspect of their initial request. We kind of punted on it. Anyway, it's just a troubling aspect.
No, but I think an appeal was taken, I may be wrong here, because it's, once we write these decisions, we stay out of what's happening in court. To the best of my knowledge, Mr. DeLuna filed appeal of our basic decision, and Mr. Dunn...
Didn't.
No, he's participated in that decision by filing, I thought, a timely cross-claim against the building inspector, asking for him to enforce the terms of the bylaw, and I think part of that was, and I may be wrong, but I thought he was saying that essentially they're using the bobcats and the construction and the landscaping equipment as part of this large sale of firewood. And he's asked Mr. Prondak to go out and make a finding or determine that, and...
But that's not a substitute for a timely 4817 appeal.
Well, you may be right there. I'm not an expert in that area.
It's an issue that's troubled me as I've looked at this, but we can reserve that issue as well. But I'd like to have more information on the 48 Section 3, both factually and legally.
Okay.
To make a valid and complete determination of this issue.
Okay, that's...
And I appreciate what you say about the 1987 part, but I mean, and I don't mean to put unfair burdens on the applicants here, but it is what it is. I mean, and so far, the only testimony that we've heard, the only evidence that we've heard, is that the operation is essentially the same. And I have to assume that the Zoning Board of Appeals in 1987 was aware of what the operation was.
Right, and the Board of Appeals in 1987 was aware of what was considered a nursery business, what was considered a construction business, and the court has said we can't regulate that under the special permit process. So I don't see the nexus there. It just seems to me, what's the difference between running a landscape and construction business and running a large wood sale business, particularly if it's not raised on the property or it doesn't come from Massachusetts and there's no tie-in? I don't know how we can do that under the special, whatever well-intentioned Board of Appeals dealt with those issues. That's what I don't understand. But, so that's where we are, folks. I think we're willing to, and we're inviting you to file additional memoranda on the issue of the Dover Amendment as it applies to the sale of firewood. And whether I suppose, incidental to that, whether this board back in, whenever we started this, and I think it was in the, like 1986 or something like that, 1987, whether the regulation of this firewood business under a special permit process is valid or invalid, or Mr. Dunn said whether that type of use requires a use variance, and it has nothing to do with what the board tried to do consistently in the 1980s and the 1990s, and until Judge Sands told us we were wrong in doing it. It's not the proper way to do it. And Mr. DeLuna, the extent to which you can introduce some by affidavit or otherwise, presumably, some specific information as to I don't know whether those records are still available to you. I can't imagine they are, but maybe they are. Some evidence at the various times of these special permits, what was the extent of the business as it relates to various other aspects of the business, so that would be helpful to my colleagues.
I sincerely doubt we're going to have records 27 years
No,
ago.
I look at it, I tried a trust case in the Norfolk Superior Court, and they went back 50 years on the expenses of the trustees, and you just shake your head. But to the extent that that information is available, we'd like to see it. The question then becomes, when can this information, legal memoranda, be submitted so that we can consider this and decide this in a relatively prompt fashion, and what dates would be convenient to you gentlemen? Mr. Dunn, do you want to be?
Well, I'm a bit at a loss, because if you're talking about you need a majority to, or you need a unanimous vote to undertake an enforcement action when Mr. Prondak refuses to take action, I don't know what information or what precedent I can possibly provide to Mr. Hurley that's going to change his position, because he's raised a number of extremely complicated issues that he doesn't sound like he's going to be persuaded in any shape or form. And what you're asking my clients to do is undertake considerable amount of
I think he's looking for
legal work.
information on the legal issue, particularly of the
I think
Dover amendment.
part of what his argument is that there's been a waiver of some sort with respect to the issue that's before this board. And this board's decision of September 26th, Section 4, and it's Exhibit C, number 4 on page 14, contemplates that there's going to be subsequent action by Building Commissioner Prondak to inspect the property to determine what is incidental or accessory to the nursery business. And I think this all comes down to, how is the sale of, in this intensity, how is this incidental or accessory to a nursery? I mean, I don't see it. And, maybe I can't see the forest through the trees here, but I don't mean to re-argue this whole thing, but I'm trying to just be reasonable here and conserve resources for everybody here. And, if we can't even agree if you can't agree as to what your own decision says, I mean, I don't know what information I can provide you.
Well, see, the problem is, Mr. Prondak, because he was waiting for an opinion of town council, has conducted, I think, a preliminary investigation from the best I hear. And he has this legal issue that town council hasn't responded to, and admittedly, it's been a long time in the waiting. I suppose, let me ask my colleagues this. Does it make any sense? Because we don't know, Mr. Prondak hasn't acted, okay? So, to the best of my knowledge, but I won't say he's failed to act, because he's waiting for an opinion of town council. What's wrong with ordering Mr. Prondak to conduct the investigation and to give us some type of order, one way or the other, so that you can preserve your legal rights and appeal from it, or praise his decision.
Well, I think that I think it's 48, Section 7, contemplates a requirement for him to respond or take no action within
14 days.
14 days.
That's
And that hasn't been done. And, this train is moving forward, and I don't want to replicate efforts and expenses of my clients to get them back to the same situation we're sitting in now. So, if a unanimous vote is required, then, let's have a vote, and, we all know what the next steps available to all the parties are here. So, I don't want to expend effort in my client's resources, and respectfully, Mr. DeLuna's resources, and this board resources, if a determination can be made this evening, because, or a definitive vote can be made, one way or the other, because, these are legal issues that can be addressed, in a 48 Section 17 appeal. So,
Well, the question you're going to have is what factual predicate you have if you get into the Superior Court on this particular issue. You may have an incomplete record. Mr. Hurley's telling you he thinks he would like to see additional legal precedent on the Dover Amendment aspect of this, and Mrs. King is telling you that she needs more specific information, and that information was important in the original decision for Judge Brian, help me, Brian Davis, to make a determination that the primary use here was no longer nursery, but a construction business.
I'm happy to provide this board with that information and legal argument and affidavits as to that aspect. But with respect to the waiver argument, I encourage you to read your own decision, Mr. Hurley.
I've read it many times, so you don't have to encourage me.
Okay.
And you shouldn't presume that I've made up my mind on this. If you think it's a waste of time to present additional information, that's your issue. I just raised it as a concern. I didn't read that decision as saying, go out and tell us whether you think the sale of wood is incidental. We all knew about the wood issue. I don't think the sale of wood is incidental. That wouldn't be the basis of a decision for me. I want to know, and I haven't heard much from you about the 48 Section 3 argument tonight. I'd like to address that issue. And then, and if you think that the 1987 special permit is, that we can decide in 2014 that the 1987 special permit is invalid, I'd like to see some authority for how it is.
I'd be happy to do that.
How we would do that. And I wouldn't think that would be a waste of your time to do that.
Right, and isn't it your position that they need a use variance to conduct the sale of firewood business to the intensity that they're presently utilizing the property?
Or it has to be shown that the intensity level right now is somehow incidental or accessory to the nursery business.
Right.
See, I don't see that as an issue in this case. I don't believe that it's incidental to the nursery business. My question is it permitted under the statute, or is it permitted under the 1987 special permit? So there's two issues on the 1987 special permit. The only evidence that we've heard tonight, other than your conjecture, is that the volume and the intensity of the use is the same today as it was in 1987. I understand that you may not be able to come up with contrary evidence with respect to that, but you should try. But perhaps the better argument for you to make, and I'm open to suggestion on this, is that the 1987 permit is irrelevant because it's illegal. But I'd like to see some authority that says that as a board sitting in 2014 can invalidate a special permit that was issued some 20-odd years ago. Those are the issues I would like to see addressed.
Mr. Respectfully, the only reason why I keep saying incidental to a nursery is because that's the language that's used in the 1987 decision. And that's what allows the sale of firewood in the first place in the property.
I understand that, but they granted the special permit. Whether they were right or wrong to have done that, they did.
I know, but it's qualified. It's to the extent that is incidental to the nursery business.
But then it becomes important to know what it was in 1987, because obviously they thought whatever that was going on in 1987 was incidental to the nursery business. And the only thing that we've heard so far is that it was of even greater volume than it is today. So I don't know how we can decide that it's not incidental now when they decided, based on presumably what was the information before them then, that it was
I
incidental.
understand the information you're looking for.
And that's a legal argument, largely.
I understand.
Yes, Mr. Johanning.
I'm not an attorney, but going back to the 1967 special permit, it seems to me that the intent of the permit was to protect the residential character of the neighborhood. That was the primary purpose of the 1967 special permit. And one of the things that it talks about a lot is that the level of business should not increase over what it was at that time. Now, I know we've discussed that previously, and people say we don't know what it was. But I would love to see evidence that there were trucks coming from Vermont in 1967. So the idea of the special permit from the very beginning was to protect the residential character of the Scotts Woods neighborhood. And now we're talking about 18-wheelers coming once a week during a season that lasts from September till January. You know, I think, you know, we can dance around legal arguments, but let's remember what was the original purpose of the special permit, to protect the residential character of the neighborhood. And let's remember what we're talking about. One semi-truck per week. Now, I don't care what kind of moving bed you've got. When the wood drops out of the truck, it makes a lot of noise. And I don't know about this Vermont stuff, but I do know that in 2012, I was behind a truck from Maine. It had a Maine license plate. It was attempting to make a left-hand turn from Hillside Street onto Forest Street, and was having a great deal of difficulty. And it was on my way to work, which was 7 o'clock. So, you know, I don't know about all this Vermont stuff, and I know it had a Maine license plate, and I know it was 7 o'clock in the morning. So, I mean, even that, the truck was having an extreme difficulty making the left-hand turn, and it was backing up traffic on Forest, and it was backing up traffic on Hillside. In the way the neighborhood is, the way the streets are, it's not constructed for 18-wheel semi-trucks, which is an indication of what is the neighborhood like. And it just doesn't accommodate 18-wheelers. It just doesn't.
Okay. Mrs. Oldfield, do you want to? Miss, excuse me.
One of the, if you look at when Hillside Street actually became part of and recognized on the National Historic Register, one of the main reasons was it was recognized for the agricultural use that it was. If you look at one of the permits that I got from Mary today, back in 1938, a building permit was issued for a greenhouse, and it said it was 11,000 square feet. So the whole area, why it's on the National Historic Register, is because of agriculture. And if you even go back in more recent history, Hillside Street was never paved. I could not ride my bike down the street. I could not rollerblade down the street. And if you all remember, it was full of potholes, and that's kind of how the neighbors wanted it. And we understood that, because it slowed the traffic down and it kept traffic out. And I believe you cannot interfere with commerce. And I think you cannot say a business cannot be there and then regulate how the product gets there. If it could be on a flatbed, it could be on a trailer, but I'm pretty sure Mrs. McGettrick told me that years ago, that it does not matter how your product gets to your business, you can't interfere in commerce. Also, I have another question, is you guys regulated the landscaping business? So my question to you is, if Thayer Nursery Landscaping becomes a completely separate business, can Thayer Nursery still sell product to Thayer Nursery Landscaping?
Well, you've got counsel to give you an opinion on that. That's not our
So you guys,
function.
I think, I think it's become an enforcement nightmare for Joe, and I feel badly for Joe, because he has to listen to both of us. And my question is, and it's not, Frank I don't think knows it, it's to you guys. How are you guys gonna enforce if we are able to sell to landscapers in town, but we can't even sell to ourselves?
Look, I'm not going to get involved answering rhetorical questions.
Well, we're just going to create more
We're going to
traffic.
create more traffic. If our landscaping trucks are parked off-site, and we're able to sell to Thayer Nursery Landscaping, that means our Thayer Nursery trucks are going to have to drive down Hillside Street, get loaded up with product by Thayer Nursery. That way our plant sales are going to be higher. You guys are, and then all of a sudden it's going to go out to a truck.
Let me be frank, okay? We here to decide a narrow issue that's been raised by Mr. Joe Henning and Mr. Rowe and advocated by Mr. Dunn. We're not going to give you advice on your business. We're not going to give you advice on splitting businesses. We're not going to try to tell you how to run your business. The real question here is, are you entitled under previous decisions and/or a recent decision to engage in this activity? That's the case we're going to decide. We're going to decide it as quickly as we can. And if you need corporate advice, if you need Dover Amendment advice, talk to Mr.
I thought it was
DeLuna.
here for just Joe's non-enforcement.
We're here to deal with the narrow issues dealing with this application. Let me ask you this, gentlemen. Today's the 7th. I want to conduct the next hearing as quickly as we can, but consistent with your being able to get what type of evidence you can, and to give you a reasonable time to brief this matter so the case can be decided one way or another. Brian, how's your schedule?
I'll make anything work. I have no vacation plans.
And I have these surgeons come out and Josh's meeting in February, so we'll look at it.
Do you have a date you can agree upon in January?
Does it have to be a Tuesday, or is it any day? or-
No, it can be any day.
It can't be in March, though. That's ridiculous.
Yeah, March is ridiculous, and you all feel through one of you February. No.
I'll be away the last week.
Forever?
You know, I won't be back till early March.
Go valid to myself.
Yes, we.
Mr. Dunn, do you want to suggest a couple of dates, and we'll see if they're convenient for Mr. DeLuna?
Tuesday, the 28th.
Let's, how about something earlier than that, sir?
I have, the next 2 weeks, I have motions and trials. The 13th through the 23rd.
Well, I don't want to break your heart, but I'll tell you, as of the 27th of January, I am long gone, and I will be back in March. So if we can have a hearing within the next 2 weeks, we'll get this thing decided, and everyone can save their legal rights. But if it goes, if you can't do that, then
14th, maybe? Tuesday the 14th?
Week from tonight.
yeah.
It's okay.
That's fine.
22 or 23?
How about the 14th, Mr. DeLuna? That was suggested.
you're asking,
14, today's the 7th, that's 1 week.
It's a week.
No.
no chance of moving it to the 22nd or 23rd?
It's 23rd. The 23rd might work for me.
Okay, I can do the
That's
23rd.
fine.
23, yeah, I can do that.
What time? Does it make any sense, the usual time, or is that,
7:30?
I have to check on the wrong, but you know, both attorneys and you back.
yeah, well, you can get a room, get the room at the library, or go to the elderly center or something.
Yep, we can do that.
Don't schedule
We have
anything
to.
else that night.
We'll find a room.
Yeah.
It's too soon.
Written submissions on the 21st?
It would be helpful to have.
Yeah, that would be helpful.
Yeah.
That all right with you, Mr. Dunn?
Yes.
Mr. Devono, what about a time on the 23rd? Do you want to do 7:30, or do you want to do something earlier? Is that better for you?
Have any idea what the traffic's gonna be that night?
It's going to be miserable, like it always is.
Because I'm coming from the other side of Boston.
Yeah, but we expect you to take a hotel room somewhere in the area and just show
Yeah,
up.
we'll pay for it, don't worry.
7:30 would be a preference, that will get me through rush hour.
Okay. Mr. Dunn, 7:30?
Yeah, that's fine.
Okay with your clients? Yes. Okay. All right, so we're going to continue this hearing until January 23rd at 7:30 at a conference room to be determined, so just come down here, we'll have a sign on the door for upstairs. Written submissions by the 21st, and would we expect evidence other than affidavits and written materials?
I'm not sure what I'm gonna discover. You're asking me to.
I understand.
You know, the first thing I wanna do is sit down with Maggie
Remember
and
we had a
Josh's
fire,
mom.
no what?
Yeah, sit down with their mom to the best of her recollections. I think the 48 Section 3 argument, quite frankly, is easy. It's not an issue. So I can come up with something on that.
Okay. Okay, that's great. Sorry we've taken so much of your time. I think at least we'll have a complete record so that everyone can go see Judge Davis, if he's still sitting there. I don't know whether he is. Thank you for your time and consideration.
Before I open the public hearing, let me apologize profusely for having made you guys wait all this time. I suppose we should have anticipated that this would take longer than we scheduled for, and I apologize for that, and thank you for staying around.
Well, the good news is that new neighbors got a chance to say hello and get to know
Oh,
each other.
that's great. So let me open the public hearing. My name is Brian Hurley, and I'm going to serve as the acting chairman of the board this evening in Mr. Leonard's absence. To my left is Virginia Donahue King, who will be a board member this evening, and to my right is Theodore Daber, who will be the third member of the board. And the public hearing this evening, which was originally scheduled for 7:45, was on the application of Martin and Christine DeMatteo, is that, or is it?
DeMatteo.
DeMatteo. And it's
DeMatteo,
dated
either one.
November 25th, 2013, on file with the board. The variance seeks relief from the terms of Section 5A1 of Chapter 10 of the general bylaws, which are the zoning bylaws of the town of Milton, so as to demolish an existing single-family residence and construct a new single-family residence at 41 Fox Hill Lane, Milton, which property lies in a Residence A zoning district. Plans of the new residence have been prepared by Campbell and Smith, architects, on a set of plans dated September 16, 2013. Those plans, which are part of the record here, show a guardrail of a proposed widow's walk to be 37.1 feet above existing grade, whereas Section 5A1 of the bylaw prohibits any portions of a structure from being more than 35 feet above existing grade. The floor area of the second floor of the main body of the residence is 1,408 square feet. The floor area of the third level attic area within the confines of the 4-foot line under the sloping roof is 1,118 square feet as proposed. whereas Section 5A1 of the zoning bylaw limits floor areas within the confines of the 4-foot line to 2/3 or less of the floor immediately below, and that calculation would bring you out to 938 square feet rather than the proposed area of 1,118 square feet. So there's two separate variances that are being sought with respect to this new single-family residence that's being proposed. As part of the record before us, we have, as I mentioned earlier, we have the application. We have a letter from Mr. Prondak dated November 22nd, 2013, advising the applicants of the need to get relief from the Zoning Board of Appeals. We have a site plan for 41 Fox Hill Lane, prepared by Peter R. McManus, which shows the proposed structure on the site. We have a set of elevations prepared by Campbell Smith Architects. We have 3 pages, I'm sorry, more than 3 pages. We have 4 pages, A7, A6, A5, and A4, showing various elevations of the proposed structure at 41 Fox Hill Lane. In addition to the application materials that I've just indicated, we've also had correspondence submitted to the board by way of email. 3 separate letters, one from Susan and James Ferreira of 30 Fox Hill Lane, expressing their support for the variance, and I won't take the time to read the entirety of the email, but they do express their support. We also have a letter of support from the residents of, by Sean Fahey, who writes in support, but I'm not sure.
202 Old Farm, he's at the corner of Old Farm and...
Okay, he doesn't indicate that here. And then finally, we have an email from Richard Hamill to the board expressing his support, and he and his wife own and live at 44 Fox Hill Lane and have so lived there since 1971. So those are the materials before the board at this point. We've not, to my knowledge, received any opposition, at least in writing, to the proposal. So I'll leave it to you, Mr. Corcoran, to present this application.
Thank you, Mr. O'Brien. Ned Corcoran here on behalf of Martin and Christine DiMatteo, who are the applicants. I brought one other sort of a prop, and that is downloaded a copy from the town's website of the map of the area, and I highlighted in yellow the lot in question. This is 41 Fox Hill Lane. The Ferreiras live here at 17. The Faheys live here on the corner of Fox Hill, and the Hamels live here. And the Hamels are here.
Yes.
And I've forgotten your name. Rosa. And they live at the end of Fox Hill.
Okay.
So the good news is we just had a great opportunity to meet Rosa and the Hamels, spend some time and really explain what's being proposed. So I'll leave to them whether they have any issues or questions when I'm finished. But essentially what we're looking for is 2, I think, minor dimensional variances of the bylaw. One is clearly, I think, a need for a variance. One is a real question as to whether it's a variance, but assuming that it's a variance, it's fairly minor. The Widow's Walk, which you can see on the front elevation A5, is really just sort of an ornamental structure on the roof. There is no Widow's Walk itself. It's a sort of a railing that kind of runs in a rectangular way essentially along the ridge of the roof. The ridge of the roof itself is at 34 feet. The railing comes up 3 feet above to 37 feet. The bylaw speaks to exemptions for height for things like spires, domes, cupolas, or towers. That's under section 5A2, the general bylaw. This is a similar type of structure, I think, specifically identified as such a structure. It's an ornamental piece only, there's no structural component, but Mr. Prondak, I think out of an abundance of caution, has determined that this raises the height of the structure, even though the height of the railing is lower, as you can see on the plan, than the two chimneys that are in the same portion of the roof.
Right.
So that's one component of the relief. The second component of the relief is I think, more substantive, and that is that he's determined that the area of the attic area of the building is about 180 square feet over what would be allowed. I think the maximum allowed, according to his calculation, is 938 feet. His calculation of the plans is at 1,118 feet. The difference is 180. It's about 12% increase over what would be allowed under the bylaw. The dormer, which is shown on the rear elevation, would be Plan A6, is where the dormer actually exists. That dormer, shed dormer, creates the need for the variance here. That portion of the property, of the house, is really not visible from any place except the rear of the lot. So it is an important part of the building from the DiMatteo perspective, but in terms of its presentation to the street, the dormer itself is invisible to abutters and to neighbors. The DiMatteo lot is about 270 feet deep from Fox Hill Lane to the rear, and what's behind that is a large wooded area that is owned in trust. And so, and I have extra copies of that same.
Okay, great.
Share these with, showed them to the abutters before, let's share them further. So, really so the fact that you have a very deep lot and that dormer is really only visible from the rear of the lot, I think really renders the notion of a somewhat, 180 square feet for a fairly significant house. It's a relatively minor variance. So that's the basis of it. And so with that, we've met with, as you see, there's support from 3 abutters. We did just meet with the Hamels, who had earlier submitted an email in favor, and then Rosa, we explained, gave her an opportunity to review. I'll leave it to them to let you know whether they have any further questions. I think we answered their questions prior to the hearing, but we'll leave it to that. And with respect to that, we'd ask the board to consider granting relief.
Before I turn to Rosa, do any of the members have questions? Mr. David, do you have any questions for the applicant?
What is, so the house then would be constructed, a new home, in conformity with the plans? And what's the exterior? What does it look like? In terms of the composition?
The exterior is wood composition. It's a Georgian Federal. It's designed by an architect who is a member of the Historical Commission in Hingham. Duxbury. So he's paid very careful attention to the historic notion of a Georgian Federal and what is included and what isn't included. It'll be clapboard siding, wood siding, set back appropriately on the lot. There's not enough width on the lot to get that extra 15 feet, which would allow a full 3 stories. So if he's close, but not quite close enough. He's not able to get, as of right, the 3 stories. So we're over 2.5 stories by a small amount. There'd be a clapboard, we think white, painted with asphalt shingle roof.
And it's fair to say then that everybody in the neighborhood was consulted about it and there was no opposition?
There's no not that we know of. We've met with now all of the neighbors. Some chose to write in favor and others were silent.
I don't have any other questions.
Virginia?
You said that the land behind the residence or potential residence is owned in trust. Who owns that?
What's the name of the trustee?
It says Leslie Apple, and there's a trust with an address in Albany, New York, that is, I'd say, almost certainly a commercial address. It's something like Commerce Street or something like
It's
that.
about a 15-acre,
19.8
19.8 acres, so very large, undeveloped, substantially undeveloped tract.
But there's nothing in the ownership of that land that would indicate that that must be forever undeveloped.
Correct. That we know of. Nothing that we
wouldn't know about
we haven't
that land.
investigated
Mhm.
that. There is no direct access to that lot from Fox Hill Lane. There's an old paper street that comes in, comes to their lot line.
And that's, which lot is that again?
They live at the end of Fox Hill, so,
This house here?
yes.
And the paper street comes in here?
Paper
Is
street
that it?
that comes in, this is a private way,
Mm-hmm.
excuse me, this is a private way that comes in from Canton Avenue,
Mm-hmm.
comes way out
Is
to
that,
Canton Avenue. And then this is paper street that exists along the frontage of their lot. They own the fee in this lot, and they own the fee in this lot. I think there's a burden by of a paper street that comes in along here.
So the owner of this here extends how long? Okay. And what is this, do you know?
There's a house here. I think these are old houses from an old compound.
That are in what condition?
I don't know. I think this is lived in. I don't know what the condition of this is.
Okay.
And then Highland Lane comes in off of Highland Street. Fletcher Steel development is here. This is a private way. I think it's a dirt right-of-way that comes in.
Okay.
Presumably at some point, this could be developed. The setback from here is about 180 feet from the rear of the house to the rear lot line.
Mm-hmm.
Any other questions? Does anyone else that's here this evening want to be heard either with questions or in support of the application or in opposition? Since we're just a few of us here, let's see, if you have something to say, please give us your name and address and speak up loudly and let us hear from you. Do you have anything you'd like to ask or say about this proposal? Please, you came here and you've waited for 2.5 hours. If you have to say, if you have something to say, feel free to do so. So you have no objection to this proposal? Okay.
Can they give us their
Can you
name
just
and
give us your name and address?
Oh, yeah. I live in Fox Hill Lane, Fox Hill.
Okay.
What number?
I'm Zhang Ye, 60.
60?
Yeah, 60, yeah.
And the names?
ZHANGYAN. You can call me Rosa.
H-A-N-G.
YAN.
Y-A-N.
Yeah.
Well, thank you for coming and thank you for waiting for such a long time to,
Can I ask one more thing?
Sure,
Could you-
please do.
And I know Mr. Corcoran said this, but which is your, was it up
This
here?
is the one, yeah.
Okay, I thought it
Yeah.
was. Okay, thank you.
Okay.
Did you folks want to speak either in support or in opposition?
In support.
I sent a letter in,
Okay, and your names are what?
Richard Hamill.
And you continue to support this application as you did in your letter? Okay. without meaning to suggest anything in terms of outcome, I feel like I have to ask the question. If you had to lop off 180 square feet from the dormer, I take it that could be done. I mean, you could have a dormer there.
You would not have a dormer.
You would just eliminate it for the 180 square feet?
You wouldn't, it wouldn't make, you'd not, it's 180 square feet in excess of 4 feet over. If you didn't have this dormer at all, you'd be almost over Joe's interpretation of that by zoning bylaw.
Okay. I'm not sure I understand that.
What he means by almost over?
Yeah.
Yeah.
The calculation, the calculation of the area under the portion of the roof where there's 4 feet structural is slightly less than the maximum allowed. So the dormer kicks it over. There's enough of a dormer that kicks it over by 180, but it would still, you would end up with a dormer that was so small you wouldn't have a dormer.
Okay.
To stay.
You wouldn't have any dormer.
So you wouldn't have a dormer.
You wouldn't have, there would be no dormer because you're just about at the maximum level without that dormer. With no dormer, you're using Joe's interpretation of this, which, to add my 2 cents in, is not correct, is not what the words say, would make it, you couldn't have a dormer.
Okay.
I don't know what I'm sorry, I don't have that square footage. But that square footage is
over 900, exceeding 4 feet. It's 900, exceeding 4 feet.
Right.
Without a dormer.
And the maximum allowed is 938, exceeding, according to the interpretation. So the delta is such that you couldn't have a dormer.
Okay, I understand. That's helpful because I mean, in my own mind, I'm thinking to myself, well, why are we granting a variance for 180 square feet on a new house? This isn't the usual stuff that we get here. But if it means you couldn't have a dormer at all, then that presents a slightly different picture to me. Okay, anything further you want to present, Mr. Corcoran?
No, thank you.
Any additional questions from?
Yes, I'm not sure I got that calculation. There's no possibility of a dormer without,
I'll let these guys explain it.
yeah, I'm not seeing that.
So the dormer adds some additional area that's more than 4 feet above.
Right,
Okay. Without the dormer, you have the 2 slope.
right.
The area that is more than at 4 feet, the maximum that you can have and be 2/3 of the floor below you
Right.
is 938 square feet.
Mm-hmm.
With this configuration, you're at slightly more than 900 square feet.
Mm-hmm.
When you add the dormer, you increase the amount of area that is more than 4 feet, because you go.
No, I get that part of it, but what I don't get is having, why is a smaller dormer not going to make it?
Well, you might have you'd have a very narrow dormer that's really not gonna, it's not gonna add any value to the house in terms of the living space that you might think about in the 3rd floor, because it's so small.
Well, basically, a dormer is just for light. It really isn't for living, though, is it?
I've got a dormer, a new dormer in my house, which accommodated a bedroom on the 3rd floor of our house. It enabled the 3rd floor to become occupiable. Now, it didn't go beyond, the size of the dormer in my house was such that it didn't go beyond, it didn't create an issue of more than 2/3 of the square footage below it.
Right.
But it made it occupiable.
I guess my point is, This is a new house. It's not trying to retrofit anything into prior constraints that already exist. So we end up with something that's going to be in excess of 2.5 stories. And you were at the hearing 2 hearings ago, where we're talking about buildings that already exist, pre-existing, that are problematic, so that people can't add on later and so forth. And so I see building a new house as a golden opportunity to not have to go for any of these variances at all. And so I'm wondering why it is that we need to have this kind of variance on a house, which is a large house. Why do we need to do this, and why can't we have, you know, a dormer that might not be giving as much room as one might like, but would fit the property? It seems there's a lot of other ways that the living space that's required could be incorporated into this site without having to go for variances. And I'm wondering why that hasn't been done.
I'm not sure I can answer the question, other than the fact that the architect and the owner have designed something that's in keeping with the Georgian federal tradition, the dormer off the back. It is a large lot. There's a significant amount of area in the rear. It affects the rear of the house. And I just think it's a reasonable accommodation in terms of what's being designed here. I agree with you that out of whole cloth, they could design something that's slightly smaller and would work. It's similar to some other houses here in town, on Harlan Road, larger lots, 2A zoning as opposed to single A zoning, but I think it's something that's reasonable, it's in scale, it fits, shared it with the neighbors, seems to be okay. The other one, 2 hearings ago, was a significantly different case.
No, I understand, but what I'm saying is that, you know, this area behind here, I realize there's some distance between it, but again, this is A zoning. At some point, you know, this is going to be built up. It's not going to be as built up as Brookside Park will be because it's a Residence C district instead of an A. But, you know, you're going to have the expectation of having a little bit more room here as well. So I just...
No, I understand, but...
Can I?
Yeah.
May?
Sure, I mean, the setback in the rear from this house is 180 feet. I mean, it's a significant setback. So the fact that what is behind it might be further developed is not going to be done with any, I don't think, any effect on what's there as opposed to what's here. I don't.
If I may, I think the answer might, to put, say, a 25 square foot dormer, which would be, say, 5 by 5, wouldn't give you any usable space in this, at this level.
What she's asking is...
May I? Well, that's a different, well, I have my opinion as it does. Let's make that argument.
Picture that shows it?
What's that? I don't know.
Yeah.
Right?
Yeah, the rear elevation, yeah. It's on the rear of the house. That's it right there.
Put a lesser house in.
Yeah.
That's this. I don't see
And
that
that's how
picture.
long,
No? I guess I'd say, why wouldn't you just give me that?
So, this is an alternative rear elevation. It doesn't have the dormer, which can be built. It does have the widow's walk structure. I think that is more attractive than this, and I think that's the purpose, is to build something that's it's more attractive.
And you're getting more usable.
You're getting more usable
space, although we do not plan to finish it.
I guess the distinction that's being made, and this is more deliberative
Is this an
than,
extra copy that we can keep?
You may,
Mr.
yeah.
I mean, the distinction that is being made is really between old houses that need to be upgraded and expanded and new houses. And I think philosophically, one could argue that we can live with granting variances even though we know they don't meet the statutory criteria when we're allowing people to create living space that's sorely needed, as opposed to this situation. I mean, I think.
That's a fair assumption, yeah.
And that we really ought not to be granting variances to sort of accommodate designs of new houses, which are perfectly large without the variances. I guess that's sort of the philosophical point that's being made here.
Well, yeah, I mean, I don't want to turn the zoning bylaw on its head, which, you know, I'm kind of doing here. I mean, I realize it's not a giant amount that we're doing it by, but it's significant.
Well, we can deliberate on this point in open session once we close the public hearing aspect. I don't think anybody else has anything to say about it. Is there anything that either Mr. DiMatteo or you, Ned, have to say?
No, I think what's being proposed is reasonable. I'm not sure what, I understand the issue of variance. You know, I've been doing enough of these to know that it's never something to be taken lightly. But I think this is a reasonable alternative. It's a more attractive alternative to what he can do as of right. And so, based on that, I think we're asking for that accommodation.
Can I just ask one question to clarify? So, with the design under this drawing, what would the square footage of this upper level be? It would be, do you know, I mean, would it be less than the 938 then?
Yes.
I mean,
Yes, it's less
but
than the
not-
938.
But not clear exactly what,
It's over 900.
somewhere between 900.
900 and 938, but
Yeah.
it's less than 930, it's less than 938.
Okay.
Okay, well then why don't we close the public hearing, Ted, unless you had something further? And at this point, we'll deliberate as we're required to do under the open meeting law. As you know, it takes unanimous vote to grant a variance, and let me ask Mr. David to comment first.
Can I defer, this is actually my first case involving a new construction,
Okay.
so I really would like to hear from your
All right.
perspectives.
You kind
if
of
that's
know where
okay.
I'm coming from already.
Okay, I take it you would be inclined to not approve
That's
this
correct,
variance?
yeah.
And largely because it's new construction, we're not sort of accommodating situations where we have undersized lots because of fairly antiquated zoning bylaws where people can't make really reasonable and necessary additions to their homes if we hold to the line of the zoning bylaw. And we've sort of philosophically, over the years that I've been on the board, sort of, as long as there's been no significant neighborhood opposition, been fairly liberal in granting variances in those circumstances, whereas I think historically we haven't been so liberal when it comes to new construction. In fact, I can't even remember a case where I've been asked to grant a variance in new construction in all the years that I've been on the board, frankly. So Ted, I don't have a lot of experience with new construction. I've been doing this for over 15 years now. I don't remember a case where we were asked to grant a variance on a brand-new house. So I don't know if that helps you at all.
It does, actually.
You want to share your thinking?
No, it helps me in the sense that, I mean, it shows what a rarity it is and maybe gives some effect to Virginia's position.
I know that you closed the hearing, but the Fahey's own the corner lot, 202. I represented them in September, or last fall, for variance from the side yard setback, or the rear yard setback. That's a recent home with a new addition that had plenty of room to have been accommodated with respect to the construction of the addition. There was no objection from neighbors.
And Ned, here's a problem, because I sat on that board, and I almost said no to that. So now, is this going to bite me in the behind because I wasn't holding to a level that I should have perhaps in September? I think that's not the best way of looking at this, because that exactly shows the problem, that if we start granting these, even if it's just one here and one there, you're going to have people saying, well, you did it for them, how come you're not going to do it for me? And that is a problem. Then we look like people that are swaying in the wind. And I think that's not where we want to be. I think when people come before this board, they have to have some kind of reasonable expectation of what it is that they have to show in order to receive what it is they're asking for. And it's not just a question of, gee, can we get the neighbors to agree? Because I have seen time and again where neighbors will say, I didn't disagree with my neighbors because I like them, even though I hate this addition. And I hated it then, and I was afraid to say anything. And that's why we have the zoning bylaw, because people shouldn't have to say something about it to preserve the neighborhood, to preserve their friendship with their neighbors. And I think that's what we need to look at here. We want to apply the law consistently. And if we didn't do that in September, and let me tell you, I almost didn't do that, and now I'm kicking myself. So that's a piece of what comes through here, is that we've got to be consistent so that people come before this board and they have a reasonable expectation of what can and cannot be granted.
You make a persuasive case, and I would be inclined to join you in voting no on this variance. You
Are
asking
both
on-
of you
on
saying
both?
that on the Widow's Walk too, or the door, the
The
square
Widow's
footage?
Walk is
or-
pretty, but, do we
Well,
want to say, yeah, we'll give this because it's pretty?
Well,
I don't think so.
I think the issue on the Widow's Walk is a little different, because the bylaw allows all sorts of things on the roof, cupolas, spires, domes, etc. The Widow's Walk is simply a railing.
Well, it says for buildings used for religious or educational purposes. That's on
Chimneys are allowed
section
to,
2.
but chimneys and solar energy systems extend more than 8 feet, lightning rods, towers, not used for religious or educational purposes, not exceed so high. There's,
Well, I guess you could have a 40-foot tower, I don't know.
8 feet, it allows 8 feet.
It sounds like those are all sort of functional things.
Right, exactly. I mean, a lightning rod, you want to have a lightning rod there, you don't want your house to burn down.
but is it a spire, is a dome, is a cupola functional?
Again, that's for religious purposes.
No, up above there is not for religious purposes. Of the 2 sentences up on the first large paragraph, beginning with height shall, I'm
Are
sorry.
you on A1 or A2?
A1.
And you are where?
1, 2, 3, 4 lines, or 5 lines from the bottom. Height shall be measured to the highest part of the building, excluding those chimneys, lightning rods, solar energy systems, domes, spires, cupolas, towers, and antennas, for which a different height limit is established.
But I think what that spires, cupolas, and so forth refers down to where those are allowed, which would be in the religious or educational purposes. That's about.
Prior to, I'm sorry, I didn't mean to interrupt you.
So if you look at number 2, about halfway down in that paragraph,
Yeah, but I think
Yep.
if you look at the very beginning of number 2, in a residence A, B, or C district, the following additional height limits and exceptions shall apply. Chimneys and solar panel energy systems shall not exceed the height of a building by more than 8 feet. Lightning rods shall not exceed the highest point of a structure by 3 feet. Towers, which are part of any building not used for religious or educational purpose, shall not exceed by 40 feet.
okay, that's a tower.
Not used.
That's a tower. We don't have a tower here. And then after that is when we get into the spires, domes, and cupolas. Or actually, towers in excess of 35 feet, so this, I'm reading that is that you can't have those on a residential building. Let me just read here. And that's even bigger than we're talking about, so let's not even worry about that. Yeah, I'm not seeing that that applies to,
I guess I would say it only in that a tower would have a railing. This is just a railing. And this is on a pitched roof. You can't go up here.
no, I understand that.
So you're suggesting that the
Can I
variance
add-
isn't even necessary here?
I would,
Yeah, but.
I'll let my lawyer
well-
suggest it.
Well, don't believe a variance is necessary, but the building commission's made a determination that it's not allowed, so we either need a reversal of the determination.
I understand, but your argument is that even though it's not specifically listed, it ought to be treated the same as some of these other appurtenances like chimneys and whatever.
Exactly, I mean, it's hard to,
Can I, and
It's
if I
hard to
can
define
add,
everything.
for consistency's sake, this is 627 Harlan Street. This is an existing house built about 7 years ago. According to Joe, while he was building inspector, he gave me these plans. It's such a similar house. It has both the shed dorm, it's the same architect, shed dormer, and the
Did this need a variance?
that I do not know.
Because that's really the key, as opposed to if it's a similar house or not. I think the house is beautiful, there's no denying that. But if one requires a variance and the other one doesn't, there's, something having to do with the slopes and things like that,
Oh, would it have required a variance?
that one there, yeah.
Under this, under Joe's interpretation of this, if anything, this house is higher.
Well, I guess my point is,
I don't know if it got a variance or not, is what I thought you were asking.
right. Was a variance necessary? If the variance was necessary, then apparently I got it, but we don't know that. So there could be something where there's, we are only talking a couple of feet there on the Widow's Walk anyway. So, it could be something, the house is situated a little bit lower or something along that line. I don't know the specifics of that one.
Well, I know this, and because this plan shows that this house sits, and the way they calculate the average grade is,
Right.
it says the average grade, you may have more experience with it than me. This house is actually on a much lower average grade because the rear walks out, and I got 1, 2, 3, 4, 5, 7 steps of the rear. So this would be on a much lower average grade relative to the height of the house.
And I guess that's what I'm saying, is that Widow's Walk would not have reached the level that needed to have a variance.
No, it
then.
it would have been way past.
Are you saying that that's,
variance
He's saying it's a lower
This
average grade here.
This average grade is lower because of the way it walks out. This would take a little while for me to explain.
yeah, I don't know, because that, has
Well,
a
it
different
shows it.
history for something on this.
Right.
And I know that he follows, to the letter, when his denial letters, so that if that needed a denial letter, I'm sure it got one. And I don't know what the history is.
Well,
But we should be deciding this based on what we have in front of us, as opposed to anything else that might be in town.
I agree. We don't want to go there. So it's really just on the merits of this application. And unless we're prepared to say that this Widow's Walk falls within sort of the permitted exceptions under the bylaw, then I think there's really no basis for us to sort of overturn this and to grant a variance.
It really isn't.
Okay.
I mean, it looks lovely, I'll grant you that, but
So you'd be disinclined to grant either variance?
I would.
Okay. Mr. David, how do you feel about it?
I'm less disinclined about the Widow's Walk than the the other one, but it takes three to grant the
Takes a
variance
unanimous
anyway,
vote.
so,
Well, why don't we put it to a vote, and I'll separate them. All those in favor of granting the requested relief with respect to the dormer, say aye, please. Those opposed, nay? And on the Widow's Walk, all those in favor of granting the requested relief, say aye?
Wait a minute.
On the Widow's Walk,
Nay.
nay. Is there?
well, you're asking for aye or either way?
Either way.
Nay.
Well, the vote of the board is not unanimous on either of the requested forms of relief, and so the variance therefore is denied. Without further ado, I will close the public hearing. We have to do a decision, right?
Mm.
Look at Jim right now.
That's a tough one. That's a tough one.